First of all, good morning, everyone. It's my pleasure to welcome all of you here and online to Osgoode Hall Law School. My name is Trevor Farrow, and I'm the dean here. And I want to thank and acknowledge the Jack and May Nathanson Center for organizing this terrific conference on addressing sustainability impacts of the corporation. Before I make some really very brief remarks, I just want to start by recognizing the many Indigenous nations that have long-standing relationships with the territories on which York University campuses are located that precede the establishment of this university. York acknowledges its presence on the traditional territories of many Indigenous nations. The area known as Tekaronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It's now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. The territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to care and peaceably care and share for the Great Lakes region. So I'm going to get out of the way, Barnelli, in 1 second, but this conference is quite something, bringing together remarkable speakers locally, globally, folks who are new to Osgoode, and lots of old friends. It's a great space to be in today, to look at and tackle some of the problems and harms of sustainability issues from a more holistic perspective. From questions like how do corporate governance and law, investment law, and international law address sustainability impacts on the corporation? Do these areas overlap and build upon other or worsen corporate abuse on sustainability issues and harms? And are the fixes to individual areas of law sufficient to address the problems? Or does reform in any of these areas have to align with other areas and questions? Lots of stuff on the agenda, and it's going to be an exciting day. Before I turn to the first panel, I just want to give a special shout out to my colleague, Professor Barnelli Chowdhury, not only for arranging today, but also yesterday's Orm Emmett lecture and bringing together a terrific speaker, Professor and former Dean Robert McCorkadale, who's here again today, and our colleague, Liel Gonzalez, who I think is in the room or someone around. These conferences are not self-executing. We really appreciate your efforts and putting this on, and to your entire team. So thank you. With that, I am going to get out of the way and introduce our first session surrounding public international law, corporations, and sustainability. Barnelli, over to you and the panel.
So just before we start this first panel here, and yeah, the panel should absolutely come up. I just wanted to say a couple of very, very quick words. So first of all, thank you to Osgoode for being so great and hosting us all here today. Thank you very much to Liel, who is somewhere in this room, whatever. So she is the brains behind the center. Nothing here happens without her. All of you that are here today are only here because Liel is here. So thank you very much, Liel, wherever you are. I also want to introduce you to three of my RAs are here today, and they are going to be very instrumental in helping all of our panelists today, as well as anybody else that's in the room. They're going to be live tweeting. They're going to be summarizing. They're going to be everywhere here today. So there's Matthew, Anat, and Sophie, and Lena will be here later on today. So please, come by and say hi to all 3 of them, or actually 4 of them. And then the final thing is I have to give a big thank you to the Social Sciences and Humanities Research Council, SSHRC, who is funding this conference. So thank you very much to the SSHRC overlords for letting us be here today. All right, so let's get started.
Welcome to the panel on public international law, corporations, and sustainability. My name is Galit Sarfati, and I'm a professor at the University of Toronto Faculty of Law, and it's a pleasure to be here today. Today, we're going to be hearing from 3 preeminent scholars in this area. I'll introduce them briefly now, and then we'll have lots of time afterwards for questions as well. So we'll be hearing first from Peter McClinsky. Peter McClinsky is the Emeritus Professor in International Commercial Law at the School of Oriental and African Studies and the author of Multinational Enterprises and the Law, the foremost book on the subject. Then we'll be hearing from Sundhya Pahuja, who's Professor of International Law and Director of the Institute for International Law and the Humanities at the University of Melbourne. She's also the lead on a major multi-year collaborative research project on global corporations and international law. And finally, we'll be hearing again from Barnali Chowdhury, who's a professor here at Osgoode and director of the Nathanson Center on Transnational Human Rights, Crime, and Security. So now I'll turn it over to Professor McClinsky.
Hello, thank you very much. I hope you can all hear me. Thank you very much to Barnali for inviting me to be present today. I wouldn't be able to be there physically, but I think one of the benefits perhaps of the pandemic is that we've learnt to do things online more often. Now, today, I want to talk a bit about the interactions between business and human rights and corporate law reform. When Barnali first invited me, we were thinking, what should I talk about? And initially, we thought I should do a whole overview of foreign investment law, business and human rights, and corporate law, but that would obviously be far too long for this slot. So instead, I'd like to focus on one particular reform proposal today and expand from that how business and human rights informs legal reform. And that is the idea of having a director's fiduciary duty of care to consider human rights in the context of making corporate decisions. Now, this isn't a new idea. It's been mooted for some years in academic circles. Then in 2020, the European Commission made such a proposal, which made an appearance in the draft Sustainable Due Diligence Directive, but was watered down by the Council. But I really had to think about this carefully when I was invited to be a discussant with my friend and colleague David Bilshitz concerning his new book, Fundamental Human Rights and Fundamental Business, where he puts forward this as one of the major proposals for reform of corporate law. Now, before I go into what we may mean by the substance of such a duty of care, I'd like to consider how business and human rights actually interacts with corporate law, because if we take the idea of business and human rights seriously, then it's potentially a game-changing concept. Because business and human rights law questions the very functional and instrumental notion of corporate law as something that simply facilitates corporate behavior and deals with the major problem of internal corporate governance, the agency problem. And it begs to ask the question, should companies simply be looking at things like profit maximization for shareholders? And asks a broader question, shouldn't a corporation actually be responsible for protecting the human rights of people affected by its operations? Now, if you take that as a starting point, then you ask some very important questions about the adequacy of corporate law to achieve social purposes. Now, historically, corporate law has not worried at all, really, about externalities and about the impacts of corporate behavior on third parties, such as potential human rights victims or victims of industrial accidents or other so-called involuntary creditors of the corporation. And in those circumstances, to actually propose that the corporation has to actually behave in a way that observes these rights of third parties is quite a radical proposal. Now, against that background, what do we mean by a duty of care for directors? Well, Article 25 of the proposed Corporate Sustainability Due Diligence Directive stated that directors of companies should take into account the consequences of their decision for sustainability matters, including, where applicable, human rights, climate change, and environmental consequences, including in the short, medium, and long term, and that member states should ensure that their laws, regulation, and administrative provisions provide for a breach of such a director's duty. Now, David Bilschitz's definition of the duty requires the exercise of demonstrably reasonable care, skill, and diligence in reaching judgments about the substantive content of corporate obligations in relation to fundamental rights, and to take all necessary action to ensure compliance with those obligations. Now, both these proposals suggest a balancing process. And I think that's the first characteristic of such a duty, that it allows the director to balance corporate interests against human rights risks and consequences. And one of the first consequences of having such a duty spelled out is that it shields the director from liability for loss of profits, which, on the logic of the pure shareholder maximization theory of corporate governance, he or she would be exposed to such a risk if it could be proved that observing the human rights of third parties who have no personal relationship with the corporation would actually cause the corporation to lose profits. So that's the first thing to bear in mind. The second thing is, what about the substance of this director's duty? Now, David actually suggests that the fiduciary duty connotes some of the questions surrounding human rights due diligence in the UN guiding principles. And I hesitate to say, but that was an idea that I put into his head when we had the seminar before he published the book. And we had quite a long discussion about this in that context. But what I'd like to do is expose the bones of our discussion and to actually comment on what the substantive content of that fiduciary duty might mean in practice. Now, I haven't got time to talk about remedies, but I would suffice to say that I agree with David Bilschitz that effective enforcement requires going beyond existing remedies based on harm to the company or shareholders, and empowering the victims of corporate human rights violations to bring direct actions against the company and its directors. But that said, what would an emphasis on human rights due diligence bring to the substance of this duty? Well, human rights due diligence has four components: initial identification of human rights risks and impacts, assessment of their seriousness and of those most at risk, avoidance and mitigation of risks, and accounting for and remediation of human rights risks. Now, logically, this would mean that a failure to address any one or more of these elements would count as a breach of the fiduciary duty. And equally, the director has to consider the potential and actual human rights impacts and formulate a prevention or mitigation strategy. The director should also realize that human rights due diligence is a continuing process, and it's not enough to just do a one-off impact assessment at the beginning of a project, say. Now, a further implication of this duty is that it doesn't shift responsibility for human rights from governments. It doesn't diminish the first pillar of the UN guiding principles, the state duty to protect. So that I think we should also be clear about. A third element is, well, what happens in supply chains or in corporate group structures? Are directors of the parent company or the lead company in a supply chain actually responsible as a fiduciary matter for violations of human rights that are committed down the corporate management line or down the supply chain line? Here, the liability of the directors raises questions not dissimilar to those that we see in relation to the shadow director principle in corporate group cases of breach of existing directors' duties. And it's quite hard to prove, I think, in a very complex global production chain or a chain of subsidiaries, that that the lead director is actually a shadow director or its equivalent of these entities. There is also the problem that, of course, in a supply chain, you're dealing with contractual relationships. So what is the extent to which a director could be responsible for not foreseeing human rights risks occurring down the supply chain where they don't even have any kind of managerial responsibility? And there are cases under the Alien Tort Claims Act, for example, that say there is no responsibility in these cases. So we have to delimit the outer boundaries of that in terms of corporate structures. And another significant problem is foreseeability of risk. Now, the range of potential stakeholders who could be affected by a corporate violation of human rights is quite large. But I'm not with Professors Bebchuk and Talarita, who suggest in a recent critique of stakeholder theory that there is a kind of impossibilism in this, that because there are so many stakeholder groups, it's impossible to know which ones to care about, and therefore it's better not to bother having any responsibility at all. I take my cue from tort law and say, well, foreseeability can be defined on the basis of what is reasonably foreseeable, to put it crudely. The director can and should be able to identify on the basis of the evidence before them who is a foreseeable victim, just as much as a tortfeasor may be required to identify a potential victim of their foreseeable harmful activity. Now, a further factor that must be included in this duty is that there has to be an effective engagement with stakeholders and ensuring that the director has access to sufficient expertise to be able to make an informed human rights judgment. I mean, one thing that I see is that corporate directors are not the best placed people by terms of education or experience to be human rights risk assessors, and they have to have in place mechanisms by which they can gain information and speak with stakeholders who are likely to be affected, and also to take expert advice where necessary. And this is also important from the point of view of compliance, because we can't have just a formal tick box exercise type of compliance. Compliance would have to be based on proof that the risk has been reasonably foreseen and reasonably acted upon. And in those circumstances, some degree of expert analysis would be required. And this also follows then to my next point, which is about what standard of care should be applied. Now, David Bilshitz in his analysis refers to the business judgment rule. I think partly because it applies in South African law, and he is a South African law professor. Now, in the UK, we don't have the business judgment rule as such, but we do have a director's duty of care rule that acts sort of in the same way. I haven't got time to go into the details, but the basic common principle is that the courts are not comfortable reassessing business decisions and therefore give a duty of care on these matters, which is reasonably generous in giving a margin of discretion to directors. But that's all very well when we're talking about commercial decisions in the interests of the company. But when we're talking about decisions that affect third parties who have nothing to do with the commercial behavior or activities of the company, we're in a different territory. And there, I would argue that actually the courts would be required to act as judges of public interest and to apply something closer to the tort standard of the duty of care rather than the corporate director standard, so that we would have a higher human rights standard. That seems quite sensible to me if we're really going to go down this route. And that brings me to my final point. Is company law the best place to deal with human rights liability questions? I wonder whether we will be talking a little bit about that in the discussion, because using company law always creates the risk that the courts or the legislature will actually favour commercial considerations to the point where human rights concerns don't get a sufficient grounding in the law. And there are two things in particular that worry me here. First of all, it's quite hard to isolate a human rights oriented decision from broader commercial decision-making context. And if commercial and human rights issues are mixed up, as they almost inevitably will the courts interpret the new fiduciary duty rather lightly as a result? And a court may well decide that the director, who, after all, as I said, is not a human rights expert, could discharge their duty of care rather easily, given that human rights implications of a particular business decision may have been hard for them to foresee, given the limits of their expertise. And you could see that the logic of the kind of business judgment director's duty of care rule might affect the way that courts interpret. Second thing is that, of course, where we stand at the moment, there's always been a primarily voluntary approach to corporate responsibility for human rights, as enshrined most obviously in the UN guiding principles or the OECD guidelines. And this may condition the court's approach, that the new fiduciary duty, therefore, would have to make clear that this is a mandatory standard of care, and it has to be expressed in quite unambiguous statutory language. So there it is, briefly, some food for thought. I'm still in the process of figuring these things out more fully, but I look forward to answering questions a bit later on.
Thank you so much, Professor McClinsky. Now we're going to turn it over to Professor Pahuja.
All right. So, hi, everybody. And thank you very much to Barnali for inviting me and to Leo for doing all of the hard work. Sorry, I'm sure you also did a lot of hard work, but Leo clearly has been corresponding with all of us to set all of this up, and it's just beautifully organized. So when Barnali first wrote to me some months ago now, she told me that she was running a project on addressing the impacts of corporations on human rights and the environment. And she said that one aspect of that project looks at the role of public international law and why it has been unsuccessful in regulating corporations. And she asked me to bring to bear on that question some of the research that I'm currently working on, which interrogates the relationship between international law and global corporations through an historical lens. So I'm going to be speaking in a very different register to Peter and possibly to others at this conference, but I'm guessing that's what Barnali was hoping for as a provocation to thought. She's assembled a pretty eclectic group of us here. And it's still very much a work in progress. So I wanted to take this chance to share some relatively new thoughts with you. But I think that intuition that you articulated, Barnali, that public international law has been unsuccessful in regulating the corporation is pretty widely shared. So even though there are some diehard optimists who might think of business and human rights norms or norms attached to dispute resolution procedures in other economic fora, I think generally the idea that public international law is letting us down is fairly widespread. But what my research is increasingly revealing is that when we think historically about the relationship between corporations and international law, what we see is that almost from the beginning of what we tend to think of as international law, companies and corporations have shaped the making of international law. And perhaps more surprisingly, international law and its precursors have been central to the formation of the corporation. But at the same time, there are disciplinary routines of international law, including the splintering of jurisprudential thought into different professionalized disciplinary silos like private international law, public international law. And our tendency to assimilate questions about the corporation and international law to the register of political economy, which have obfuscated the centrality of international law to the ongoing formation of corporations, and the inverse, the centrality of corporations to the formation and authorization of European international law. So in other words, once we begin to historicize the relationship between corporations and international law, at the same time as historicizing both the formation of the discipline and the state form, you can see why this project's taking me a long time, the materials quickly invite us to invert Barnali's question. So instead of asking why public international law has been unsuccessful in regulating the corporation, or its more normative corollary, how should international law regulate the corporation better, the historical questions become, how has international law facilitated the emergence, stabilization and institutionalization of the corporate form and the movement and expansion of the corporation? And how have the corporate form and corporate actors facilitated the stabilization and expansion of a particular European version of international law? So these two questions are what I'm working on at the moment, and will produce a book on in due course, perhaps in some time to come, and a spin-off documentary with my friend Ruth Buchanan. But the way that I'm undertaking the investigation is to take key moments in the history of international law and look for the company story. Or to put it more formally, to interrogate the relationship between companies, states, other organised groups, and plural laws to figure out what's going on, and specifically to ask what world was being made by what means and what was happening to contestation and rivalry in those moments. So what the method entails is troubling and pluralizing our conception of corporations and of international law, and indeed of law itself, but at the same time attending to practices of formation and the way that legal technique gives shape to the forms that life can take. I realise that's quite a lot to take in all at once, but some of these moments include familiar milestones in our disciplinary history, but which look quite different if we demythologize them or try to travel back without an anachronistic idea from the present about the corporation or about the state or about the law, or with binaries like public and private, which are anachronistic in that context. But we've become so familiar with them, we think of them as ahistorical. But my moments will also include less predictable moments, which are more unexpected in the history of international law, but which turn out to be central once we triangulate company, law and state with this pluralizing or jurisdictional lens. So just to bring us down from that realm of the abstract to the concrete, just one example of a familiar moment I want to make strange is to ask what difference it makes if we take seriously the idea that Hugo Grotius, who for the non-international lawyers in the room is widely considered to be one of the fathers of international law. What if we take seriously the idea that when he was writing one of his most famous texts in the early 17th century, he was actually writing a legal justification for a captain of the Dutch East Indies Company, who happened to be one of his cousins, I believe, who seized a Portuguese ship carrying goods worth a figure comparable to the total annual revenue of England at the time, which was an act of plunder on an unprecedented scale and which caused a sensation in Europe. But the 15th chapter of that book, subsequently published as Mare Liberum, in that chapter, Grotius explained that the high seas should be regarded as a free zone for both states and armed private companies, and that his cousin was well within his rights. So that's just one example of what happens when you take a familiar moment, demythologize it, and take seriously the idea that there's a company at the heart of that, and that the company-state relation was not as we imagine it to be now. I can say more about the unfamiliar moments in question time, but I'll leave them aside for now, because what I want to do for my phone's stop. What I want to do for what I think is my remaining 9 minutes is just to focus on one slightly different type of example, which I think draws out the way in which international law is both central to the corporation as we know it and reveals the need to look for disciplinary practices of international law which obscure that centrality and might be more relevant to some of the concerns of people in this room. Well, one of the disciplinary tendencies that we can observe about ourselves as international lawyers, so don't all shout at me if you don't do this, but anyway, I think is our tendency when we speak about the corporation to speak about it as though we know what it is. We international lawyers, I hope you would agree, Rob, we tend to leave the history and theory questions about corporations to corporate law theorists or history questions to historians and simply to treat the company as a private non-state actor. This tendency, I would argue, causes us to naturalize the corporation as an entity and arguably to think of it as a natural emanation of either the market or of capital, depending on our politics, and to think of the form of power that it exercises as economic or political economic power, and to imagine its existence as exogenous to law, and specifically exogenous to international law. This naturalized image and the idea of the corporation as an economic entity which exists prior to law tends to be shared by both critical and mainstream scholars and across the political spectrum. And it's not confined to international lawyers. I think you can detect this tendency, for example, in John Ruggie's work as well. I could say more about what I think causes the image to be naturalized, but I won't for now because in my remaining 5 minutes, I just want to jump on one feature of the naturalized corporation, which I think we take for granted, but which has long puzzled me as a historical question and which I'm trying to work through at the moment. This is the assumption shared across the disciplines and sub-disciplines of international law that corporations incorporated in one state are recognized in another. Simple idea. And yet this assumption is what allows corporations to exist in multiple locations at once and to benefit strategically from the ability to organize their activities across multiple legal systems. But as far as I can find, few people seem to have asked how it has historically come to pass that if one state has decided to confer a particular status on a group of individuals, why other states have recognized and given effect to that status and what the implications of that might be. So in this double question mode that I have explained and I'm trying to get moving, I'm interested in figuring out both how it has come to be and how it has come to be unremarked upon that corporations can, as it were, travel. So this is a question that I'm investigating with my collaborator at the Lauderpact Centre, Andrew Sanger. And our intuition is that the ability to cross borders and to exist in multiple places at once hinges on two related legal ideas and is embedded in particular imaginaries of the corporation. The first is the idea that corporations are considered to be nationals of a state. And the second is the idea that states recognize corporate personality granted under the laws of other states. Now, as I say it, I'm hoping you think, but those things are obvious and banal, but that's precisely what I'm trying to draw out. I want to make those ideas strange. So nationality makes corporate movement possible, but in our argument, it's not self-evident why corporations should be considered nationals of a state. Scholarly work on global corporations nearly always operates on the assumption that a corporation is a national of a state. So there's a vast literature determining what nationality a corporation should have for specific legal purposes, but there's very little on how it came to be accepted that corporate personality could travel across international borders or on the role of nationality in making this possible. And this is true even for those who argue against it or who argue about refining the test for corporate nationality. So there's some incredibly important work on the arbitrariness of investor nationality, for example, and the ease with which corporations can claim nationality for strategic benefits. And here I would direct you all to the fantastic book of Anil Yilmaz-Vastadas sitting with us in this room on the nationality of foreign investors. But I'm asking a slightly different question, which is to interrogate this assumption underpinning most work in international law that a corporation is a national of some state. So a question not of which, but whether. Okay, nearly finished, I promise. I can see that you're all riveted though. Okay, so the answer to this question though is turning out to be very long, and figuring it out is still a work in progress. Tony Unge, who those of you who are international lawyers will know is a kind of originator of studies of imperialism and international law, has recently written in the European Journal that he's working on a history of human rights, which locates the origins of human rights in protecting the corporate alien. So that's one piece of the story. Another moment that Nick Peroni will be very familiar with is the jurisdictional reconfigurations that happened in the decolonisation of the Americas and the United States and its rise and its corporations and the Monroe Doctrine and the US approach to Latin America in the 19th, 20th century. And the corporate lawyers in the room will no doubt know that in the United States itself, there was a huge debate at the turn of the 19th century about whether corporations should be recognised from one state to another. And until that view shifted in the early 20th century, the view was that juridical persons could not take their law with them. So there was no personality when the law runs out. So in the European context in the 19th century, a corporation could have no existence outside the sovereign territory which was said to have created it. And instead, it needed to be explicitly recognised by other states. So European states entered with each other into treaties of comity by which they agreed to recognise the personality of others' corporations. These treaties also explicitly extended those rights into the quote unquote dominions and possessions. So the colonies of those states. Is that the end? Okay, can I have one more minute? But there's a battle in the 19th century in Europe between those who regard those treaties of comity as matters of grace, that is something that one state must explicitly grant to another, or matters of right, which are part of a sort of natural law idea. But of course, what about the South? What allows a corporation's personality to be recognised in non-European states? And this is, of course, where empire fits in, because there's a whole tapestry of laws that, for example, allow a British corporation to hold on to its personality in India. And it involves a whole lot of intra-imperial laws. It involves mirror legislation. It involves international law rules where the treaties that Britain enters into with others are applicable in India. So basically, there's a network of what Christopher Tomlins calls the laws of colonisation, which combine international law, intra-imperial law, local law, and so on. And the primary purpose of these laws is to safeguard the colonizers' interests, including property, contract, consular laws, and so on. All of this means that at the time of the great decolonizations of Africa and Asia in the second half of the 20th century, there's a great deal of jurisdictional flux and activity to ensure the continuity of such protections, not only of investment, but of the identity, the personality of corporate persons. So when Rob yesterday was talking about how much legal knowledge you need to get a grasp on business and human rights, the same is true to try and understand the jurisdictional tapestry that's operative in this moment. And I tend to think of it as a bit like in the myth of the universalization of international law at the end of empire, under that smooth water of universalization are thousands of duck legs paddling like this, which represent all of the jurisdictional activity that is necessary to hold those corporate interests in place and corporate personality. So it's true for the involvement of corporations in the drafting of new constitutions, Cadbury and Ghana. Other examples, it's true for the reform and introduction of corporate laws in the new colonies. It's true for the emerging law of development. It's true for negotiated independence. It's true for the negotiation of debt. It's true for thousands of adaptations and innovations in doctrinal international law around acquired rights, rules around succession, birth of investment law, the birth of development discourse, all of which are not unrelated to the maintenance of the recognition of corporate personalities such that the corporation can travel. So, in essence, international law has to continue the work of the laws of colonisation in that regard. And there's lots of new work on the battles around this, but still not very much work on the question of corporate personality. Just to conclude, I would say, well, why does any of this matter? So what? As I always say to my doctoral students, so what? Well, I guess the big so what for me is that the moments that shape the law are important because they're moments in which particular interests and visions of the world compete with each other and one vision prevails. And there's something to be learned by studying the emergence of principles that are posited as universal from the specific contexts that produced them and the interests that prevailed and ensured the authoritative nature of the principles that followed. But I guess that for people in this room who are more interested in what we should do, the normative questions that I'm avoiding, there are normative possibilities in denaturalization and historicization. So instead of thinking of international law today as, to borrow the words of Gary Simpson, virtuous and marginal, once we pay attention to the world-making effect of international law, we see that it's constitutive and powerful. And so instead of imagining the corporation or the global corporation as a behemoth over which we must cast a net of law in a fairly desultory and difficult way, we can have a rival image in our head of something like the cover of Leviathan with all the little people joined together who make up the big sovereign and think, well, if law is what makes the strings that hold all the little people together, it's much easier to think of activities and practices which we do that create the strings or activities we can do to snip the strings than to imagine the behemoth that we must catch outside law. So I'll stop there. Sorry, I won't look too long.
Thank you very much. Finally, we'll turn to Professor Chattery. Okay, so I think that's working. So first of all, thanks everybody for being here today. Now you get a chance to understand why I've assembled this eclectic group of people. So this is the thinking behind this conference today. And this is this idea that I'm very much at the infancy stage of working on. So will be interested to hear what you think about it. But that is to think about what are the interconnections between corporate law, international law, and foreign investment law, and what does that mean to the idea of corporate sustainability? So I start from the idea of what we already know. So we know really that corporations routinely violate human and environmental rights. So we know that there are fashion companies that are living off the exploitation of laborers in China and Bangladesh. We know there are fossil fuel companies that are perpetuating climate change. We know that there are mining companies that are involved in forced labor. And we even know that there are seafood farming companies that are engaging in a range of human rights abuses just to catch a bunch of squid. But what I think is difficult to understand is how to conceptualize problems of corporate sustainability. So is the question a corporate law problem? So certainly the corporate lawyers in the room will tell you that if only corporations understood that their purpose was for more than just maximizing profit, then there would probably be less impacts on sustainability issues. But maybe it's a foreign investment problem. So international investment lawyers will tell you that corporations, particularly when they're acting as foreign investors, that they tend to violate human rights and the environment. because investment treaties allow foreign investors to weaponize ISDS, which is something you'll hear about a lot today if you don't know already, investor state dispute settlement, which allows them to challenge state efforts to be sustainable. But maybe it's also an international law problem. And so that's because international law regulates states, but they don't really regulate corporations, even when there are instances where the corporations are more powerful than the states. And this leaves corporations free to do as they please. So instead of approaching this problem from these three different silos, what I thought might be helpful, and as I said, I'm still thinking about it, is whether we should be viewing this problem more holistically. So one in which the problem is viewed through the interconnections between corporate, international, and foreign investment law. And here I'm drawing from Karen Alter's theory of interconnections, which she uses in a different context to view connections between international law, international relations, and colonialism. So Alter argues that the interconnections between these different areas gives rise to a regime. But she says that this type of regime is not purposely created. Rather, it appears as one law is layered upon another, which leaves holes of unregulation and the ability of actors to pit different levels of authority against one another. So I think that we can see a similar type of regime that's being formed by corporate law, international law, and foreign investment law when they are working together. A regime that we might call something like transnational business law, although I haven't quite yet decided on a name yet. So this is the regime that allows a corporation to form, establish a profit maximizing purpose, take that purpose with them as they become an international actor, and move easily from one jurisdiction to another, and then use the legal protections that have been given to them to operate without regard to other interests and to operate with very little oversight or accountability. So I think that the value of viewing corporate sustainability through this interconnections might provide us with some insights into the problems of corporate sustainability that we are missing when we view it as a siloed problem. So before we get into these interconnections, let me briefly sort of sketch out how I see the three layers of law interacting individually with issues of corporate sustainability. Of course, we'll hear a lot more about that today from the experts in the room, but this is just, sort of my starting point. So if we think about corporate law, then one of the reasons that corporations commit abuses of state sustainability issues is because of the driving purpose of corporations, which is to maximize shareholder wealth. So the focus of the corporation then is, it's centered on shareholder interests, and it allows them to privilege these interests over other stakeholder interests. And while they're privileging shareholder interests, that's combined with another lovely feature of corporate law called limited liability. And limited liability enables the shareholder to limit their liability to their investment in the firm. So when we rely on these principles, then corporations can structure themselves as a group company, and then they can locate subsidiaries around the globe. And then they can then channel risky activities to undercapitalized subsidiaries, using that to externalize their harm, including in the form of human rights and environmental abuses. And then they get to escape relatively unscathed, since limited liability is going to shield their assets from the creditors and the tort victims. So the second area is the law of foreign investment, or international investment law. And this is the law that protects corporations and foreign investors from host state interference when they establish investments abroad. Now, the traditional aim of bilateral investment treaties, so those are the treaties that form this basis of the law, was really to propel the development of the host country while also protecting foreign investors' interests. But somehow the development aims of these treaties seem to be downplayed, or particularly when arbitrators are interpreting the law. Rather, international investment law has a tendency to prioritize or constitutionalize the property interests of corporations, or strengthening the power of corporations vis-a-vis the host state, while at the same time lessening the state's ability to protect sustainability issues. And in part, this is because international investment law contains this feature known as ISDS, or investor state dispute settlement, that acts as a direct proxy for corporations to assume increased power against the host state. And this tool, along with a number of other elements, which our speakers will enlighten you about today, is they're used by corporations to challenge host state regulations to protect sustainability issues. And finally, the third area is public international law. So international law should actually play a vital role in this area in providing oversight over corporate sustainability issues, because corporations that cause the most severe corporate sustainability impacts are usually multinational corporations, which tend to be international actors. Yet, as we've already heard from a couple of our lovely speakers today, that international law has really kind of struggled with this idea about how to deal with these actors. So under international law, only states or international organizations are subjects, meaning that international law applies only directly to these actors. And so it doesn't apply directly to corporations. But in many cases, we see that corporations are really as powerful or even more powerful than the traditional subjects of international law. Yet international law seems to retain very little direct authority over them. Instead, international law has tended to focus on creating norms or using different types of soft law to voluntarily shift the activities of corporations away from sustainability harms with, in my opinion, limited success. So human rights due diligence, which Robert McCorquodale spoke eloquently about yesterday, is probably the most prominent outcome of international law's approach in this area. But corporations, for their part, I think, have really benefited from the lack of oversight from international law and sort of the soft law approach, because it allows them to operate in areas where there is no regulation, what we call the governance gaps, and the ability, obviously, to move from one jurisdiction to another with very little accountability. So how do these areas interact with each other? So again, as I said, very, very early stages of research, but this is kind of how I'm seeing these interconnections working. So we have corporate law codifying the strategic operations of the firm toward a financial goal, and that prevents or downplays corporate managers' ability to tend or pay attention to non-financial interests. We then have the corporation then drawing on this model when it becomes a multinational corporation. So now it's driven by its financial ethos, which has been established in its home country, and then it then exports this model to the host state. And the model is then used by its subsidiary and also as a basis for contracts with third parties in the host state, such as with suppliers. And then in the host state, the corporation's financial goals model is ensured by the area of international investment law. So international investment law establishes the importance of the corporation's property in the host state. And it also reminds the corporation of its ability to disregard or downplay any sustainability goals that are imposed upon it by the government by giving it this trump card known as ISDS. And meanwhile, international law is encapsulating the entire operation of the multinational corporation, since it is operating as a transborder or international actor, but it's not viewing it as a subject, and so therefore it's not regulating it directly. Moreover, we have international law working in tandem with corporate law, which ensures that a multinational corporation, even when it is linked through an equity relationship, treats it as an individual actor because of the ideas of state sovereignty in international law and separate legal personality in corporate law. So the law, for example, will treat a Canadian multinational corporation with a subsidiary in Guatemala as a Guatemalan company, not a Canadian company, meaning that only international or Guatemalan law will regulate it. But this gives rise to a rather perverse result. So if the Canadian company uses the company in Guatemala to exploit the environment in an effort to bring back profits to Canada, then, and the Guatemalan, let's say Guatemala is reliant on the foreign investment income from the Canadian company, so it chooses not to hold the company accountable, then we have this gap of unregulation within which the corporation becomes untouchable. And even if Guatemala objects, then the Canadian subsidiary can actually pit the Guatemalan government against other governments. So say, for example, Honduras, who also will be competing with Guatemala for the foreign direct investment from the Canadian company. And it allows the company to basically pit off these different actors, their authority, against one another. So how do we solve this problem? The answer is, I don't know. Okay? And I told you that this research was very much at its stage of infancy. But what I do know is that individual fixes to corporate law, the law of foreign investment, and public international law are probably not going to do it. And rather that we're probably going to need we need fixes in each of these areas of the law, but we're probably also going to need fixes to how these different types of law interact or interconnect with one another. So that's the purpose of today's conference, really to hear from the experts in this room in these three different areas, to talk about these interconnections and to think about how we could think about solving the issues of corporate sustainability from a more holistic level. Thanks.
Thanks so much, and under time as well. Okay, so we have plenty of time for questions. How do we want to do questions? I guess there are microphones there, so perhaps anyone who's interested in asking can stand up and ask questions to any of the speakers. Why don't you just come to the podium or to the mic?
Thanks everybody for a very interesting and great start. I have a couple of questions. I guess, assuming Peter Machlinski is there, I'm curious to ask, there seemed to be a presumption that the expertise of the board is given as opposed to changing expectations about what board expertise should require. And I wondered if you had any reflections on that, because it seems to me that the argument could be made that board expertise must include awareness and expertise in areas relating to human rights and sustainability generally. But I have questions for others too, so maybe I'll just quickly pose some of those as well. For Professor Pahuja, nothing that you said was actually a surprise to me, but I wonder if in part it's because of thinking through the lens, not just of public international law, but also private international law, which seems to me to be a bit of a missing piece in perhaps also how Barnley was approaching the problem. But that I think is because I've always thought of, you have to think of public and private international law together. Otherwise there's something kind of missing there. So on the nationality question, I also wondered, my impression from PhD research a long time ago was that often thinking about what the nationality of a corporation is depends on, it can be determined by the state, but that the state might have a different answer depending on the area of law. So nationality for tax purposes might be different than nationality for other purposes. So I wondered if you could share just thoughts on the nationality piece. And then, sorry, Brandley, I was curious as to whether you had thought or reflected about what you mean by corporate sustainability. Thank you.
Perhaps we'll start with Professor Machlinski, if you want to respond.
Yes. Thank you for that question. Undoubtedly, raising a new fiduciary duty, which has a particular skill set attached to it, creates a range of issues, which I think I briefly touched upon by saying, well, what would be the standard of care? What would be the standard of foreseeability that would get the director over the line? And hence my stressing of the need for stakeholder participation and for the use of expertise in the corporation. Now, one possibility would be to have specialist non-executive directors who are human rights experts. But we'll probably be able to discover all sorts of problems with non-executive directors that extends also to such types of non-executives. The real question is how to embed a consciousness about human rights and the need not to transgress human rights norms in the everyday management of the corporation. Where we are now is really in the early stages of consciousness creation. And one thing that matters, for example, is what's taught at business schools or what's taught in law courses. I was just reading something in a business studies journal about the teaching of business and human rights to business students, and that sort of thing matters as well. But within the immediate sphere of corporate law, then one commonly proposed idea is to have human rights specialists as non-executive directors.
Whatever you want to answer?
Yeah, sure. Of course, I agree with Peter, but on top of that, I guess the other second answer to Sarah's question is, sorry, I'm still on Peter's question though, not my own, but which is that you could have, we have remuneration experts when we're talking about how much to pay the people that sit on the board. So why can't you have like a human rights expert, right? So you would call when there's like a human rights kind of issue or something even tangentially related to that you would bring in, experts that would come in that would consult with the board on these particular issues. Some people have even suggested that we should have a permanent board member with expertise in this area, right? There's lots of work that's being done on board diversity. Board diversity doesn't necessarily just mean identity characteristics, but it can also mean what kind of expertise you have. So sustainability kind of issues or climate change or human rights or whatever it is that is important to the board, what the UNGP calls the salient issues. These salient issues should probably be reflected on the board.
Thanks for the question. I think that the connection between public international law and private international law is a missing piece in how public international lawyers have been narrating historiography of our discipline. And it has not occurred to me so profoundly until I started thinking about how to make sense of the corporation that I've realized that. So I would put to one side your question about the rules that determine which nationality for any purpose, even though I agree that there's lots of interesting doctrinal questions. My question is the historical one of at what point did it become a thing for corporate nationality to be accorded, to be imaginable? And then what happens in the decolonization era, for example, or whether that's Latin America or Africa and Asia, when there's a contest over which law applies, and there's not only European international law. So there's something that happens in the disciplinary split between public and private international law in a kind of jurisprudential fragmentation. I hesitate to use that word, but when jurisprudence splits into professionalized subdisciplines, and there are doctrinal flow and effects from that split that invisibilize certain things. So it's interesting that Barnali is talking about a gap, because in a sense, I think that your sense of the gap and my sense of the non-gap is the same sense, because what I'm saying is that gap is not a natural gap. It's a gap made through the historical emergence of rival jurisdictional bits of stuff. And that if we look for, I haven't read the Karen Alter text, but when you were talking about a regulatory web, I was thinking, well, that web is Western civilization. So that idea of what makes the thing such that some things seem unregulated, I feel as though that is a good intuition and that there's a historical piece that could work quite well in conceptualizing that putative gap.
Could I come in here? Could I come in here for a second? I've found something quite interesting in looking at the history of why the corporation was not incorporated, was not a part of international law. I think Doreen Lustig's work here is quite pertinent. And I found her book on the development of international economic law in the absence of the corporation in it very instructive, because you can see how, for example, the privatization of the Africa Company in Nigeria, or what was then British West Africa, becomes a means of disappearing the the chartered corporation into a private enterprise, and therefore it disappears from any kind of public law or international law regulation. And I think these are the sorts of historical instances that she points out, 4 or 5 historical instances. And I dare say that your work is going to actually increase our database of these historical moments where something happened, which would, as in your words, unrecognize the corporation from international law. So I'm looking forward very much to seeing what you're going to come up with.
We all are. I think we'll gather up maybe 3 questions just to have a chance for more people to participate. So if anyone is interested, please go up to one of the mics.
All right, thank you. You said that these papers were slightly randomly put together, but they seem to be perfectly aligned to form one glorious whole. Fantastic papers and extremely inspiring. I wanted to put some thoughts. I think they may be a question, but they may be some thoughts to Sandhya, and it's about this issue of a fascinating project, by the way, of what it is that we're recognizing when we're saying we're recognizing companies historically, because when we're looking at the old charter corporations, which Peter was just mentioning, and we're looking at the East India companies, for example, what we're looking at is a very small aggregate of wealthy individuals plus the state engaging in conflict, really, between other European countries for access to someone else's country. And the degree to which they're recognized is not a legal function. It's a military function because, the Dutch East India Company, if we're going to call it speak of it as an entity, didn't recognize the English East India Company, except as a sort of minor irritant, and then something that became something they wanted to swat aside. So they didn't recognize it. And it's not until you get to the historical moment of Oliver Cromwell building up the Commonwealth, building up the Navy, that the Dutch East India Company recognizes the claims of the East India Company, which is really the claims of the state. So for a long time, you're looking at the state's operation in tandem with other wealthy individuals who are also engaged in the state in other ways. The point at which you can say, well, does this become an entity or something autonomous or something with separate corporate personality seems to me to be illustrated somewhat by the development of the financial interests. So once you have a share emerging as something which is more fungible, then you see the company being able to engage globally and nationally as an autonomous being. And this is really 19th century stuff, which is I think why we see this happening in the United States at the end of the 1860s, that recognition of other corporations. So I suppose I wondered, so I think this is a function of the development of finance and capital, of which the company becomes a vehicle or an expression of, rather than something that's purely legal. So is my question there? I'm not sure there is a question. Have you considered the financial development?
Does anyone else have any questions?
That's a great starting panel. And I would like to ask questions to all of you, but I'll just focus on you, Banali, for a second. So I'm always worried whether we get anywhere if we differentiate between individual fixes and holistic fixes, because they seem to be commonsensical and right away, understandable, but they don't really, they're not operationalizable. So what do we mean by more or less state or more or less market? Your proposal that you recently made in an article to put community representatives on a board and to have that publicly regulated in your mandatory human rights due diligence piece. I'm not getting that wrong. is that proposal an individual fix, or is it not actually a holistic fix? Because you shift the politics. You say the state should actively, it's not just doing more mandatory stuff, but it should actually intervene in how corporations interact with the environment on which they have negative impact. And that's the question. Is that individual fix when you just say, well, that's nice, but it won't fix it all? Or is it actually signaling that we give the state an entirely different role in how to regulate corporations?
Maybe one more question? Yep, thank you.
Bit of Sarah's question to Barnali, the concept of sustainability. Why did you pick that? Because it's a very, when I hear the concept sustainability, I feel like someone's trying to water down things because it's so vague and can mean different things to different people. So I wondered what's kind of behind that.
Yeah, that's a good question. Okay, well, so why am I using sustainability in this? Because it's a nicer, like more concrete thing for something that you can sell to the government of Canada when you're asking for money. So that's really the sustainability in there. I really, obviously, you know that my work is really on human rights and obviously climate change and environmental rights insofar as they relate to human rights issues, right? So I believe in, you know, the UN's new recognition of the human right to a health and safe environment, right? So that's really what I'm talking about. But I'm just using this as sort of a like a short form for conceptualizing that. But that's really where I'm not a human rights person, and with climate change and environmental issues kind of brilliant. So I think that's what it is. I'm not trying to water down anything or hide anything. It was just about, it's more of a just what I needed to do. What I thought I needed to do is sell it to a wider audience. And I think if I can answer Per's question as well. So what's the difference between these individual fixes and the holistic fixes? So for me, I can't remember that I even suggested that we should put community people on the board. So maybe I have to go back and read my own work. But anyways, that's great that I suggested that. But to me, that's an individual fix, right? That is what I would write as a corporate lawyer, right? So maybe those are little tweaks. Those are corporate governance kinds of issues. Those are very, very small tweaks, but it doesn't really, and that's what I'm really interested in here is like, you know, how does corporate law, and particularly I do lots of work on multinational corporations. That's really my word. I'm not really that much of a, like what I always say to people that I'm a small C, like corporate lawyer. I do what I need to because that's the way like law is taught in most law schools. But I am an international business person, right? My world is all about moving across borders. And so if I make a small fix to, for example, Canadian corporate law, that is not necessarily going to translate into a fix into the people that I'm worried about, which is, you know, the people that are whose human rights or environmental rights are going to be affected in, you know, in the global south. And that's just, I don't think that that's going to fix that. And that's sort of what the idea is.
Okay, thanks, Peter, for your vote of confidence. And I would recommend to anyone in this room who's interested in historical questions, Doreen Lustig's book, Veiled Power, which is really good. My work stretches back further and would be a complement to that book and doing something slightly different in methodological terms. I don't know if I can say too much succinctly in response to your points, Lorraine, except to say that, yeah, the question of both how the corporation or how corporations were financed and the role that corporations and companies played in public finance are both interesting to me. So I've written about the Peace of Utrecht and the invention of public finance and the relationship between companies and the Crown in that context. And last week, Ruth Buchanan and I had a workshop involving the historian Philip Stern, where we were talking about the government by franchise, so the deeply different character of government and the way that the personnel were often the same. I don't have a fancier word. They're both often the same people who are vying for political power and engaging in corporate activity. But I suppose I would say that one of the things that I'm trying to think about, and this relates to Peter's earlier observation, is that historically speaking, if we don't get fixated on a positivist definition of law and think differently about how we think about law, then I would see the company and the state as rival forms of association and rival jurisdictional forms in a sense, which doesn't mean that they don't enter into relation with each other. So I'm trying to rethink the meaning of the corporate charter, which I think we have wrongly characterised retrospectively as an act of creation or delegation. And actually a corporate charter is more like a treaty between rivals, or rivals, sometimes friends, sometimes rivals. So there's too many things that I could say and too little time in which to say it. But thanks, that's really useful. And I want to talk to you about art as well.
We're very close to time. If someone has a really quick question, we can.
Oh, sorry, there was.
Was there any?
My bad. There was a question online. So it was said, how does the concept of public benefit corporations in the US relate to this?
I think that's for you.
I don't know.
Shall I have a go at that? Because
Yeah, sure.
I've just assessed a PhD which talks about this, and it was a very good PhD as well. So thank you to the, of course, anonymous candidate who's informed me about this. But the public benefit corporation is a new type of business association which takes care of a lot of the kind of fiduciary duty to the company problems that the dominant model of corporate law has, because it actually expressly permits the corporation to put in its articles of association public benefit goals. Now, it's not like a company limited by guarantee, which has to reinvest all its profits. It's a completely new form of corporate actor. But one of the problems with such a new form of corporate actor is, why on earth would any corporate actor bother to take this up when they can still maximize their profits in the existing paradigm? So selling this idea is a big problem. And there's a whole network of a whole NGO network that tries to sell the idea of the public benefit corporation. Now, I'm not an expert on this, but in the United States, as I understand it, not very many corporations actually incorporate as public benefit enterprises. So it's a great idea, but its time perhaps hasn't yet come. But it offers an indicator that if we take as our holistic concept the idea that human rights must be observed by businesses, that sustainable environmental policies must be observed by businesses, then we fit the specific policies around that basic norm. And with the climate emergency, I think the humanity hasn't got much of a choice, really. If we are to have a world which is still habitable, and business has the power and the capacity to provide the technologies, then we perhaps need to have new forms of business association that see public purpose as the main objective. And in a way, too, one of the problems of the contestation between private capital and the state is that historically, like, the state was dependent on private people to finance it. I mean, where did the monarchs get their loans from? And that gives you a sort of tension, which today we see in the fact that, for example, fossil fuel companies are still capable of lobbying governments to continue down policy lines that are unsustainable in environmental terms. So the battle is there. Now, my concluding point would be we've all got the intelligence to see new forms of doing business that are sustainable and human rights compliant, but we still have the huge political grinding horse that's there to stop us. But perhaps as an older person here, I could just say, as I've said on many occasions, compared to what I saw 40 years ago when I started work on these things, the world has moved on quite considerably, where we've got lots of crises, lots of problems, but I still remain moderately optimistic that we are moving forward in the right direction.
Okay. On that note, please join me in thanking our three panelists for this thought-provoking panel.
I will get started again. Thank you, of course, again, to the organizers and the participants in the last panel. My name is Gus Van Harten. I'm a professor at Osgoode Hall Law School. This panel will deal with the topic of international investment law, sometimes called foreign investment law or foreign investor protection law or the investment law regime, whatever you wish to call it. That's what we'll be talking about. And we have with us Professor Markus Krajewski from the University of Erlangen, Nuremberg. Hope I got that close enough. Professor Anil Yilmaz from the University of Essex. And Professor Nicolas Perron from the University of Valparaiso. And we will hear from Professor Krajewski a little bit about the interaction between investment law and human rights. Then we'll hear from Professor Yilmaz about the interaction between investment law and climate action. And finally, from Professor Perron about how investor obligations might fit into international investment law. Thank you.
Do I have to? No, it works. Okay, great. And then I push this. Okay, so this is Nicholas. Okay, Nicholas, this is you. I know these lines. Okay, this is Anil, and that's me. Yay! Okay, so we decided to reverse the order of the speakers and the presentations on the program because yesterday afternoon in Gus's car, we decided that the person who is excessively doctrinal should start. And that is obviously the German lawyer in the room. So we thought that I would start by pretty much looking at some of the questions of the law as it exists and maybe trying to, I don't know whether if you're excessively doctrinal, you can even claim to be holistic. So I'm probably just going to fiddle with some small issues here. So the idea of the question really is can you move this away so I can see it actually? Thank you. International investment law and human rights. And what I want to do is I want to speak about three ways of how I would conceptualize the challenges that international investment law puts to human rights. Then I want to talk about a few remedies, and that would then already sort of pave the way for Anil and Nicholas. So why is, I guess, international investment law a problem for human rights? And I think it makes actually sense to distinguish between what I would call substantial law and procedural law. So for those of you who are not entirely familiar with international investment law, it's a body of law which is made up of 2,500, 3,000, depending on how you count, international treaties, most of them bilateral treaties, many also multilateral treaties, either treaties which only contain investment protection or treaties which cover trade issues and investment protection. And I can say 95%, 90%, depending on how you do that, they all look the same. And basically what they do, they contain a number of substantive standards protecting foreign investments and foreign investors. And they combine these substantive standards with a unique system of dispute settlement, ISDS, investor state dispute settlement, that Barnali was already mentioning. So first, I want to look at the problems for this from the perspective of substantive standards. So here I identify, to begin with, two standards which we can find in almost all of these agreements: the protection against expropriation, both direct, but what is actually more interesting and more problematic for our purposes, indirect expropriation, and the so-called fair and equitable treatment standards. These substantive protections have been used against legal instruments, but also against policies and measures of states, federal systems, but also provincial, but even sometimes even local public entities, which were used to protect human rights. This is at least how I conceptualize many of these cases that we're looking at. I'm just using three examples. The first would be sort of price caps, on privatized water services. So you had, in many cases, actually privatization of water. A foreign investor takes up the supply of water, and then the foreign investor raises the prices. And then the state says, you can't do that because we need to make sure that everyone has access to water at an affordable price, or measures aimed at supporting or actually representing underrepresented groups in companies, both in company boards, but also in terms of sort of public purchasing orders, or measures aimed at protecting lands of indigenous peoples. So we see these kind of public measures by states or by governments, and I would conceptualize them as measures aimed at protecting human rights, and investors go against them because they say these are actually a violation of either the fair and equitable treatment standard, or they form indirect expropriation. In many cases, tribunals, the investment tribunals, have said yes. In some cases, they have said no. In some cases, no decision was taken. But the point is, it's not important what at the end was the outcome, but that there's a potential of investors to actually challenge these measures based on these laws. And when we look into these agreements as well, we also see that there are not just these problematic substantive provisions, but there's also no mitigating language in these treaties. So the definition of investment usually does not include this idea that investment actually has to have a positive impact on development or on societal goals. Often there is an element in there which says you can only protect investment which was made legally, but then that's basically limited to the pre-investment phase. So if something happens later on, that is no longer taken into account. Usually these agreements do not have exception clauses. So in trade law and in other fields of law, we know that there are an exception clause which says if the state takes a measure aimed at a public policy, a goal which is necessary, which is proportionate, then that measure can be justified. We don't find that in investment treaties. And then finally, even if you find some references to human rights and sustainability, it's basically just in the preambles or sometimes in treaty provisions which are not really binding. We then move to the procedural law challenges. And here, of course, one has to understand this unique setting of investor-state dispute settlement, which sort of allows investors, and only investors, in this setting to bring claims against the states. So the rights of states to address investor abuses, the state would say, well, but you raised the prices for water excessively and violated, therefore, some of our domestic laws. Those are typically, I'm making things more simple, typically not arguments which would then be heard by investment tribunals. Affected communities, local stakeholders would not have a standing in these settings. So even though their rights have been affected or their rights have been violated, they cannot make their claims heard in the setting where you basically just have the investor on the one side and the state on the other side. The calculation of damages, because these investment tribunals would award damages to the investors, is often done in a purely business economic perspective and doesn't take social and environmental costs into account. And then, of course, we have some special features of the setting itself. If we look at who is actually hearing those cases, most of the time the arbitrators do not have any expertise on human rights. This links back to the debate we had in the early session in the morning, the lack of expertise. And then there's also a particular element there, unique feature, that there's third-party funding for investors often, which creates actually some incentive for even frivolous claims. So we do have a number of problems. And I want to summarize that by saying that basically what we're looking at is a very one-sided system. So international investment agreements contain rights, corporations, foreign investors, but no obligations. And that's not new. It's actually been even recognized by some of these investment tribunals. And I'm citing here one case that was decided 5 years ago, that basically saying they have rights but not obligations. So the problem has been recognized but not solved. What can we do to solve the problem? So we could, of course, think about reforming the treaties. And there have been ideas out there. So some of these ideas is, why don't we include a clause which sort of protects the right of the state to regulate? Now, I don't know how you feel about this, but I always thought this very idea that a state needs to sign a treaty in which it actually protects the state's right to regulate is a very, very strange idea. Because from my perspective, states have obligations to regulate. Of course, they have rights to regulate. It's part of their sovereignty. I mean, why would you put that in a treaty? But anyway, that's just a conceptual footnote. So most of these rights to regulate clauses actually do not have any meaningful content because they just basically say states have the right to regulate, but no one is ever disputing that. Most of these treaty reform proposals would also look at limiting sort of the scope of the substantive protection. So they say fair and equal treatment is still there, but it's limited to a list of measures, or it's limited to discriminatory measures. Some propose increased transparency in the ISDS proceedings, but they really do not address the inbuilt imbalance of these agreements. So all of these reform proposals are basically saying, yes, there are little problems. We need to solve them through a little bit of a language tweaking, but they would not address the inbuilt imbalance. There are ideas of establishing direct obligations in these treaties, and this is a lot of scholarship has been on this, and there's always, ever since 2016, reference to a particular treaty between Morocco and Nigeria, 2016, which is still not ratified, there's not really a movement in that direction. There are some other clauses. Sometimes we have encouragement of the states of investors to adhere to human rights standards, but there's really no movement towards different language there. Another idea is to increase the participation of rights holders, creating an independent right of standing of affected communities, NGOs, or trade unions, or as a weaker alternative, at least allow them to sort of make their positions being heard. Again, these ideas are out there. They have been discussed. I don't see a lot of really movement in that direction, neither in treaty language nor in the arbitral tribunal practice. So this is why I'm suggesting maybe, and we heard about this yesterday from Robert, this idea of mandatory human rights due diligence, which is now emerging in a number of jurisdictions. And yesterday evening, we had to talk about that there's maybe also a Canadian law coming out on mandatory human rights due diligence, maybe next year, I don't know, maybe. And if that's the case, then my question is, could we read that into investment agreements, arguing that sort of if an investor is violating or not adhering to human rights due diligence, then the investor is actually sort of violating a global standard of corporate governance. And that would then mean that they could be excluded from access to investment protection through something that's called the clean hands doctrine. Or you could even say that it's part of the legality requirement. So this is maybe something that can be done if these laws, these new requirements are being thought as part of investors' obligations. And with that, let me very briefly conclude. So we have this negative impact of investment agreements on the protection of human rights. It's generally recognized. So far, we have limited remedies in actually treaty reform and implementation practice. But I'm throwing out this idea, the question actually more that maybe the standard of human rights, of corporate responsibility for human rights could become sort of something that should be read into these treaties. And with that, I thank you for your attention. Now, how do I go back? How do we go back? He can do it. He's the master of everything. Yes, exactly. Oh yeah, sure.
Okay. Well, is this working? Okay. Thank you. Thank you, Marcus, and thank you, Barnali, for organizing this and inviting us here and bringing us all together. It was perfect to have that overview from Marcus as a kind of, it's quite helpful that I don't have to go over why international investment law is problematic when we look at questions of human rights protection, environmental protection, and one of the biggest challenges of our times, climate action. So in my little presentation, I'm going to talk about the relationship between international investment law and climate action. And some of it, I think, is quite obvious to those of us that have been working in this field, that international investment law protects fossil fuel investments, provides really robust protections to fossil fuel investors, and that is problematic in the context of climate action. And sorry, no, did I do that correctly? Okay. Yeah. So as we all know, we need to decarbonize our energy systems, our societies, our economies. And that means we need to reduce our reliance on fossil fuels. That means asset stranding. So existing fossil fuel assets need to be left on the ground. So, and that is, there's been a warning by scientists that we cannot keep extracting oil and gas and coal at the rate that we're doing at the moment, in order to reach the goals that have been agreed in the Paris Agreement, in terms of keeping global warming at the level that it was identified, 1.5 degrees Celsius. So that means we need to move away from existing investments, cancel possibly some of these investments that have been at the exploration stage, and not grant any new licenses to explore and exploit oil and gas and coal investments. There's also questions around reduction of subsidies. Fossil fuel is one of the biggest industries that receive subsidies. So that's another question where governments have to take action to reduce that. But we also know that the energy sector is one of the most litigious industries. If we look at investment treaty case law, energy and mining sectors are the greatest kind of claimants. The greatest number of claimants come from those sectors. And they've had quite a few successes, obviously. And so there is a question around how does investment protection influence government's ability to move away from fossil fuel investments? If we look at investment law literature, critical investment law literature, we can see that TNR and Kutula, for example, and Gus himself has argued that investment law makes climate action more costly. It increases the cost of climate action for the various reasons that Marcus talked about, one of which is the amount of damages that investment arbitration tribunals award in these claims. And you did say that they look at business and economic considerations, but I think it goes beyond that. Gus and I co-edited a special issue in which an amazing contributor looked at the question of damages and how the way that damages are calculated in ISDS has no bearing to reality of the business world, basically. It's absolutely excessive. The amount of damages that are awarded in investment treaty arbitration awards are far more excessive than what a business would get to sell its business in the normal market conditions. So that's quite problematic because we're looking at states trying to manage climate action and use their limited resources to decarbonize. And so if they're compensating and overcompensating investors, fossil fuel investors, that impacts seriously how the risk of climate action, the cost of climate action is distributed within society. So that's problematic. We know that. But what I want to focus on in this particular talk is that we need to increase our reliance on green energy investments, on clean energy systems. And that requires huge amounts of finance and investment. We need to expand transition minerals extraction, so things that go into electric car batteries or other kind of minerals that are critical for green investments. And we need to tackle deforestation, that all of those components have relationships with investments and finance sector. And if we look at Article 2.1, paragraph C of the Paris Agreement, governments have committed themselves to making finance flows consistent with this clean energy pathway and climate resilient development. We have commitments, differentiated commitments between developing and developed states, common but differentiated responsibilities, etc. So there's been this new kind of emerging argument among some investment law scholars that actually investment law is great for green transition because investment law protects and incentivizes investors to invest in green energy across borders. And we need that investment to happen. There are legal obligations of states under the Paris Agreement and UNFCCC to make this happen, but it's the reality that we live in. And so I'm looking at how investment law shapes the conditions of that transition, that green energy transition that we need. Is it actually a facilitator of green energy transition, or is it a profiteering exercise, basically? Is it enhancing profits rather than facilitating only? Right, so the next, there. So the question that I'm then asking is whether the benefits of relying on international investment law to promote transitions outweigh the risks that it poses. And I think it's the risks are much higher than the benefits that you can get from investment law. The benefits are questionable because we have no evidence that actually international investment law does increase FDI, foreign direct investment. We have no conclusive evidence. I'm sure some empirical researchers can challenge that, but we don't have any conclusive evidence that there is a positive correlation between having more investment treaties and getting more investments. But specifically on the renewable energy context, because we need to act fast on this. We need technology to move from the global north to the global south. We need money to flow from global north to the global south for renewable energy transition to happen. There's been a push for harnessing international investment treaties to make this happen, to facilitate, to give confidence to investors that if they invest in these very heavy cost investments, because they have to spend a large amount of funds to make these investments, because they're quite extensive investments, that they will be protected, that they will have legal stability, they will have legal protections that is provided by international investment treaties and international investment arbitration. But there was a study by CCSI, and that was published in 2022, and they asked renewable energy investors the important factors that play into their investment decisions. And they found no discernible impact of investment treaties on investment decisions of renewable energy investors. They did have legal stability among the factors. There is obviously bankability of the project is the most important thing. And with that comes obviously legal stability of the political environment. But there were almost none of the investors that they've interviewed mentioned specifically investment law. And when they were asked directly, they said that they don't necessarily look at the existence of investment treaties to make these investment decisions. They will rely on investment treaties if their investment is harmed afterwards, but that doesn't factor into their decisions. So the evidence that we have points to a very maybe tiny positive impact of investment treaties to promote these investments. But the risks, I think, are massive. If we look at this saga of European renewable energy cases that came out after the 2008 financial crisis in Europe, there were about 80 claims that were made by renewable energy investors against various European states, Spain, Italy, Czech Republic, and a couple of others, as a result of a change in tariff models, how they were basically getting subsidies. There was a reduction of subsidies And in most of these cases, these investors were successful. And one academic, Matteo Farmaglia, who looked at all these different cases and he went into how damages were calculated and what were the actual losses of these investors as a result of those reductions in subsidies. And his conclusion was that these investors basically cashed in on the energy transition because their profits weren't wiped out. Their profits were reduced as a result of the measures that impacted their investment. They were still profit-making businesses, but they were able to secure massive amounts of compensation in ISDS nevertheless. So that's quite problematic. That's a huge risk. And it's a much bigger risk when we look at, so recently I've been working on this new agreements called Just Energy Transition Partnerships that are emerging between a group of donor countries and a number of global South countries, including South Africa, Indonesia, Vietnam, Senegal, and growing. There's a growing interest in these partnerships where donor countries commit to providing finance under these obligations that we see in the Paris Agreement, which is great. But much of the financing is for the purpose of de-risking private investments. And these deals also contain guarantees of legal stability to investors and stability of return to renewable energy investors. And those kind of guarantees are needed. But the plans do not look at investment treaties at all. And the negotiators that have been negotiating these plans have not considered potential investment law risks of promising a stable rate of return, of promising a certain amount of de-risking of private capital. So there are major blind spots in these energy transition partnerships, and they're in the amounts of billions of US dollars. So that's emerging as a concerning, even though beneficial partnerships, but I think not considering potential investment law risks of renewable energy investment plans are challenging. Because what we're looking at is, a disorderly climate, policymaking. There is we're figuring it out as we go. Whereas investment law tries to stabilize things. What investment law does is to keep things stable and certain for investors. But that's not what climate action is like. It's the opposite of that. So there are major risks, even though these investments are needed and necessary. Protecting them through investment law is quite problematic. Shall I stop? Is that? The other concern that I just want to mention briefly before I finish is the race to expand access to transition minerals. They can be quite problematic, again, from a human rights perspective, as well as environmental perspective. We're seeing more and more records of displacement, environmental impacts. The Business and Human Rights Resource Center has now set up a transition minerals tracker where they track human rights abuses that happen in the context of those projects. So not all green projects are green. Not all green projects are without impacts on human rights. So protecting them through investment law, again, excludes all these human rights considerations, excludes local voices and claims of recognition, as Nicholas has argued in his scholarship. So I think the risks certainly outweigh the benefits there.
Is it possible to go backwards with the slides to the very beginning? Not that very beginning. That's perfect. Thank you. So thanks for that. Thank you, Barnali, for having us here. I'm really pleased to be here with such a great company, and thanks also to your team for all the arrangements to make that possible. I mean, thanks especially to Neil and all your research assistants, and of course, thanks to Marcus and Anil for setting the scene and making great comments, and to Gus for moderating. So what I'm trying to do, a bit in the spirit of this conference, is try to bridge the gap a little bit between international investment law and business and human rights, So what can we learn from each other? What lessons we can learn, also looking at history. And to consider if it's possible, or at least to some extent, to turn international investment agreements and ISDS into something else. So I don't think international investment law has to be limited to protecting foreign investors. So the question is whether we can align whatever we call international investment law, hopefully something different of what we have today, to the Sustainable Development Goals and to climate change. So that's what I'm trying to do. I'm going to start first trying to talk a little bit about the political economy of foreign investment, particularly in the extractive sector. Although I think you can, the natural resource, I think you can apply something similar to other sectors and see how international ISDS in particular and investment treaties kind of shape this political economy, and see later how obligations can change that. But, I wanted to bring something from the previous panels, and something that also Marcus mentioned is like, as it happens with corporate law, international ISDS and investment treaties have nothing to say about third-party rights. What they do is basically they make that invisible. Like Marcus said, it's like one-sided. So basically, that's very strong. And I would argue it's even stronger in the case of corporate law, because corporate law is part of any domestic legal system where you also find the rights of other actors within that system. Whereas in international investment law, in the treaties as such, there's nothing as third-party rights or third-party standing or any kind of participation. And because of the way international law operates, fragmentation and all that, it gets even worse. So that's a starting point to make. So the political economy of most investment projects start in tables like these, where governments meet foreign investors. So foreign investors are concerned, of course, they want to make profit. But like Robert was telling us yesterday, they're also worried about their reputation. They also want to ensure that they're investing in places where the rules are kind of would facilitate making profit. So it's not just that they're interested in profit, they're also interested in shaping the rules. Sometimes they do that individually, sometimes they do as like a group, like in this case would be mining. This is actually happening in Peru, is a meeting between investors in the mining industry and the mining minister of Peru. And so these investors were willing to invest if Peru was going to do a couple of things, like ensuring that they had a friendly investment climate. And you have the government as well, which in most global South countries are interested in attracting foreign investment for the creation of jobs, for getting technology. But I mean, we always need to take into account that governments are not, black boxes. You need to get into them. Local elites in general have particular interest. And even if we assume that, governments are trying to maximize the interest of the population, which I think is sometimes debatable, the population is not a black box either. There are people living in cities and people in the countryside. And normally, the urban interest does not align with the people living in the countryside. And that, I think, happens quite a lot. So they agree on something, and normally that is if there is an agreement that the investment is going to happen. So the investor goes to a place like Puno in Peru and starts thinking about a project there and how they're going to make money, and also hopefully also protect their reputation. And what they need to do is to convince the local community that this is also good for them. This is what we talk, like getting the social license there. And it's something that is very important for business to do it correctly. So they hire these social consultants, and they try to reach out to the community and making them understand that it's going to be good for them. And there is in these cases, normally there is a lot of asymmetry of information, unfortunately. And sometimes, at least in my experience doing fieldwork in Latin America, governments are not very present when this happens. There is a bit of absence. So it's just the investor and the local community. For instance, in the case of Peru, for instance, one of the workshops that the firm did, this was Bear Creek, was only in Spanish, where most of the community was speaking only Aymara. So that, of course, creates a lot of problems just to start with. So eventually the community learned that this was the outcome of the project. So this actually is a community that has some experience in mining, but they also need, agriculture for their livelihood. And they also have, a way of life, to understand, how nature relates to their everyday life. And when they learned that this was the project, of course, they were a little worried about it. And instead of, doing what the government expected was to embrace the investment, they demonstrated, they mobilized, and this particular mobilization was so big that instead of being only about the specific project, it was about mining altogether. They even went to Lima. There were some people killed by the police, and eventually the government had to cancel the project. So when we get at this moment of cancellation, ISDS comes into play because the investor brought a case under the free trade agreement between Peru and Canada. So Bear Creek was a Peruvian firm. And this political economy I just described, in which local communities are normally on the losing side because of asymmetry of information, because their rights under Peruvian law are normally weaker than other rights because governments normally tend to have certain upper hand over them, it gets on steroids, gets even worse. And I think thanks to Marcus and thanks to Barnali, this is kind of simple to explain now. I just want to add some theoretical points about it. So it's investment agreements and ISDS. They see the relationship between investors and the investment as in like classical legal thought in terms of property. So if property is your castle, for investors, their investment is their castle. So basically, it's a very in-rem relationship, which is only about them. They don't even need to, contribute to whole state development. They don't owe obligations to anybody there. So it's like classical legal thought in the sense that even governments, they should not be even regulating. So that on the property side, you get this idea of a very strong notion of property. Property is not interpreted as like in legal realism as a relationship between property owners, the state, and all the other members of the community. It's just a relationship between the investor and the investment. There is, in addition, on a contractual level, a transactional narrative that is embedded in the picture I show you. What you see is the government getting into an agreement with the state. Sometimes there is a contract, but sometimes there is only representations and promises. What arbitrators are those who defend investment law, and Anil was alluding to that earlier, was to create certainty about those promises. Yeah. And of course, a contract normally will have rights and obligations for both sides, but here we only care about the rights of investors. So it's nothing about the obligations investors have to the community or to states, at least not in ISDS or investment law. So this narrative is embedded in the law, is implemented in the awards, and what we get is investors are described like outsiders. They are legally allowed to be blind to third parties. So being an outsider, it means that you don't need to contribute to the well-being of that community. You don't need to contribute for that community to blossom. You don't need to contribute for the existence of roads there, for instance, of infrastructure. The government just needs to keep their promises. This is what actually the kind of, thing you get out there. Then, of course, you have the question of regulatory chill. Governments don't want to regulate because of the risk of ISDS. And this regulatory gap that you get here, of course, firms fill it with corporate social responsibility and codes of conduct because they care about their reputation. But what they really resist is state regulation. And I just to finish this and move on the obligations part. Investment treaties and ISDS operate as a sword, of course, so investors can attack states when they pass certain regulations, but it also works as a shield. So in the Lago Agrio situation, Chevron and Ecuador, that was a decision in Ecuadorian courts against Chevron for quite a lot of money. And what the investor did, it used ISDS as a shield. If your legal system actually is a little bit, I don't trust it that much, so I get these arbitrators to say you cannot enforce this decision against me. So it's a sword, but at the same time, it's a shield. So basically, the outcome is our investors go into a place under a legal regime that allows them to be blind to what happens in that community. So basically, if we think about the way most legal systems operate, is that we all have rights and obligations. That's a sort of, the social contract that is there. We also need to give something back to the community because we are taking something from that community, either natural resources, education, we are using the infrastructure. Well, investors have a bit of a different ticket when they get into host states. So can obligations help us here? And I use the DeLorean, you might remember it from Back to the Future from the movie, because I also want to get a bit of a, inspiration from history. And here I think I'm following from Sandy. I'm not as sophisticated as Sandy did it earlier, but I'm trying. And the thing is that if we look at history, foreign investors have been more worried about investor obligations than investment, or they were more worried about investment obligations than more for investment treaties. Just a couple of examples. I'd be happy to expand. I probably won't have time. So when the Ito Charter was negotiated in 1948, investors were really against it, not because weak protection, but because of weak of the obligations, particularly Article 12. They were very against the UN Code of Conduct for states and multinational corporations. The code was supposed to have obligations for states and for investors. They were fine at some point in the 80s with the obligations for states, but they didn't want to know anything about obligations for them. And the last time was in Rio in 1992. Peter Hansen, he was the director of the UNCTC, the United Nations Center for Transnational Corporations. And he went on record saying that the US and Japan threatened him, saying no obligation for transnational corporations, don't even think about it. So Peter Hansen proposed a sustainability criteria where I was also opposed by investors. So very strong going against them. So all these governance gaps that we have today were co-created. I completely agree with what Sandhya was saying. They are not accidental. There was a lot of effort from investors to get together and ensure that the gaps are there and they can be filled with self-regulation. So these gaps are the lack of state regulation, and there is a response using self-regulation with that. So can we reverse engineer that? Can we bring investor obligations? Is it feasible? How much time do I have? A minute. So it has to be very quick. So I'm just going to make one point. When you talk to delegates about writing investor obligations into investment treaties, they say they don't want to do that mainly because they don't want investment tribunals to decide on questions of domestic law. Because as Marcus put very clearly in one of his recent papers, what states have to do is to incorporate human rights obligations and environmental obligations into domestic law. And that's one of their main obligations under international human rights law. And those obligations apply to investors. Now, what states really don't want is that those obligations that they are required under international human rights law, they don't want those obligations to be interpreted by investment tribunals. So as a solution to that, what I claim needs to be done is to bring obligations into treaties and not human rights obligations. I think we can get a lot of inspiration for Article 12 of the Ito Charter. I think we can get inspiration from what the group of eminent people proposed in 1973-74 in the UN. And I think we can get inspiration from what the UNCTC proposed in Rio and was rejected. And instead of that, what we got is what the World Council for Sustainable Business proposed. And these are just to finish. I think it's not a way of, tinkering with investment treaties and try to get a balance and allow states to regulate, but rather to change completely the way we think about international investment law as a field that not only creates rights, but that also imposes obligations, which is what pretty much every legal system does. So I'm not asking a lot from investment law. It's just to do pretty much the same thing every single legal system in the world does. Thank you.
Thank you very much to the presenters. Thank you for the microphone. We have 25, 30 minutes, depending on how much we want to relinquish our lunchtime. And I would love to hear from anyone in the room. Would you please approach a microphone? And I did some, yeah. Please, the floor is yours.
I'm Dirk Matten. I'm the Hewlett Packard Chair in Corporate Social Responsibility at the Business School of York University at Schulich. So I'm, as you know, coming from the shallow end of science, yet I really enjoy having worked for the last 20 years with colleagues in the legal world. And here's the thing, and the question I have to the panel, really. A lot of what I do and what I teach is educational and undergraduate and even MBA. It works. In executive education, I face a quite substantial wall at times, simply for the reason that business engagement in social responsibility, and particularly respecting human rights, which is a big issue in Canada with the mining industry. You know, it's a huge issue. It's basically voluntary. Yeah, it's done by companies for maybe reducing costs, enhancing revenues, managing risk, and keeping the license to operate. But there's just self-interest driving this. There's very little risk and fear because the legal context in which human rights for business are implemented are either bound to the Westphalian notion of nation states enforcing that, or voluntary global agreements, which exist, but they are voluntary. Is there a way, and we can think about soft law, we can think about law as a tool for incentivizing or disincentivizing certain behaviors. Are there things in the legal toolbox which would make me go into my classroom and teach about business and human rights as a thing that business actually has to take into account as a business proposition? Because unless we come to that point, nothing is going to happen. Thank you.
Thank you very much, Dirk. I'll take one more question now. If Sunday, please go ahead.
For a fantastic panel. So forensic. I loved it. I have a question that might have a really, really stupid answer, but I'd be interested to hear your reflections because I don't think the obvious answer is the only answer, which is if there's no empirical evidence that investment law encourages investment, and there is empirical evidence that it's bad for development, and there is empirical evidence that it's bad for the environment and for human rights and for local communities, why do so many students want to do it? No, it's genuinely a question because if the only answer is money, then that's fine. But it doesn't seem to me that tells the whole story. And all of you and Gus have written about what interests are served and what history has led to this bizarre regime that if you tell someone on the street that a company can sue a state in a one-sided way in a secret court with three commercial dudes in arbitrating, the intuitive response is horror. So why do so many students want to do it?
Do you have a question too, Barna?
Maybe she can answer. She should answer.
Because I wanted to, you can ask three, right? When we can collect.
Sure.
So,
That'll be fine.
sorry. So Nicholas didn't get to finish his presentation, and I want to know what are these investor obligations that are not related to human rights, and that will also follow up nicely with Dirk's question. Thanks.
Okay, great. Okay. Why don't we just go along the panel, and you can address any of the questions you wish. And since the last one was for Nicola, how would you like to begin?
Of course. Yeah.
Thank you.
Thank you. And thanks, Barnali. And thanks for the question. In fact, I had that's exactly what I was going to do, well, the types of obligation. I said, I think you can get some inspiration from this previous exercise. So my point is international investment law as a field has never been only about investor rights. It's just, that there were winners and losers, and the winners are the ones who got the rights and the losers are the ones who didn't get anything. Those are mainly host states, like capital importing countries, and I guess then the people living in those countries too. So what types of obligations? If you look, for instance, on the ITO Charter, Article 12, that was a proposal from Mexico back then, and there were mainly two obligations. One was that international corporations, foreign investors, should not interfere in domestic politics. That was one. And the other one was that any investment should be aligned and contribute with host development projects or plans. And so I think there is, and I want to say that there is a local component in some of these obligations, like the host state, the host community. And those are the ones that I think are more difficult for international investment law today. There is another set of obligations that I would propose, which is investors should also contribute to global problems or planetary problems or challenges. And that would go with climate change. Now, if you look at the ECHO, or just to be more specific, what you can tell business students or students at a business school, if you look at the ECHO award, I think Philip Sands, he managed to deal with the planetary problem. Investors need to be aware, and they need to know when they invest that there is climate change. They cannot expect governments, to give them stability forever. But international investment law has serious difficulties to deal with the local dimension. And of course, capital importing countries, host states, they really want to know that investment, Marcus said that in the very beginning, is going to contribute to host state development. It's going to contribute to the SDGs. So I guess that will be my two type of obligations. And they don't need to be very specific. We could have a minimum standard of something. And we know that arbitrators are very creative at interpreting those standards. So if we get a different type of tribunal, which I think we would need to get for this kind of disputes, I'm sure they will be able to interpret something that is going to be, as Peter Muchlinski said earlier, that, in 40 years' time, maybe get us to think more optimistically about it. Yeah, and I leave the questions for Sandhya's question to Anil and Marcus.
Thank you. Just on the point about what do we tell business students? There is now a model bilateral investment treaty from the Netherlands, which does integrate. I mean, it's only a model. I don't know if it has been actually enacted in any of Netherlands bilateral investment treaties, but it does actually integrate a duty to carry out human rights due diligence, as in the UN guiding principles. It refers to that. So that could be and the Netherlands is basically a gateway to investment treaty protections, because many investors do incorporate shell corporations in the Netherlands to get Dutch investment treaty protections, because they're the best and the most extensive, and it's easy to incorporate in the Netherlands. So I think if they do this, and if they actually these treaties become signed and ratified, if the Netherlands actually does use that model, that could actually change certain things in terms of, from the Westphalian sense of the, of legal obligations. So that will be one thing that is not there yet, I think, but it could be a thing to provide to business students, I guess. On Sandhya's question, I don't know the answer to that. I think there is my best guess is that there is this buy-in to the idea that investment law is a facilitator of rule of law, and that it's a public good in some ways, that that's how it's being taught in textbooks and law schools, as a enabler of rule of law in in countries where that doesn't exist specifically. So I think that is the bias. I mean, when I was a student, I thought that was a very neutral and sensible statement. But, as you look at, as you grow up, you start challenging those views. But that's how it is taught in most law schools, I think. So that.
Thank you. Yeah, maybe to the question, why do so many students want to study international investment law? I mean, apart from what I just said, I think it's also the way how we teach the law in general. And of course, for many of us, it's much easier to say we have cases. We don't, if you teach international law, we are looking at abstract treaties, but then you have these cases, and most of these cases have actually relatively straightforward facts. I mean, if you try to study, if you look into the facts of investment law cases and compare that to the facts of like an anti-subsidies or an anti-dumping case in front of the WTO, I mean, I teach both, and I never understand what anti-dumping duties, how they are calculated, and zeroing on bed linen. I mean, you don't want to talk about that, but you want to talk about, mining in certain countries or stuff like that. So I think also the cases are much more concrete, and the law is so easy. I mean, it's basically a basic standard. You shall treat the investor fair. And then everybody has an opinion of what's fair. And then you can see what the arbitral tribunal said. It's a very easy way of teaching public international law. And then students realize it's an easy way. And this is the only field where you actually can go to a law firm and make money if you want to do international law. So I don't blame the students. I think it's the system that attracts also many researchers, I should say. I mean, you'd be surprised how many people actually become international investment lawyers overnight because they just read a couple of awards, Anyway, so maybe also to Dirk's question, can I just say, well, if you don't fix the problem at Schulich, how should we fix the problem? So, no, I mean, seriously, I think part of the problem, and this is at least what I observe in German business schools, part of the problem is, of course, also what they're being taught as what is the business model, what is the business objective. And I'm not an expert on your curricula, of course, but if that doesn't change, the only answer will be then there will be a reaction or there's a change if there are reactions in the legal systems. So what we see, I mean, this is not a topic of our panel, but if I just may use 2 minutes or so, 1 minute, what we see in Germany right now, and also in Europe, the adoption of these due diligence laws actually change the reality in many companies. I mean, they change it in some companies where they really think, okay, we now need to reconfigure what we're doing. In others, it's just the ticking the box exercises. But I mean, the funny thing is, all of a sudden, there are these jobs out there for human rights officers in companies. And, these people who do these stuff in the companies tell us that the fact that there's a law actually makes their life much easier. All of a sudden, the board is listening to them. The CEOs are listening to them. So I think when it comes to that very practical answer, also what you want to teach in a business school, if this becomes part of the legal framework in which companies operate, then this is what you need to teach.
Thank you very much, Marcus. I'm going to offer two really quick comments. First, for Dirk, I think the best option in the realm of investment law is the barring of access to investor-state dispute settlement. Could be communicated to business executives as a real significant loss of potential protections and rights. And there are actual cases that do bar access based on, as Marcus presented, the clean hands doctrine. So that might work. And the second thing I wanted to comment upon in response to Sandaya's, just an anecdote. I did my LLM. No, I did my PhD. He was doing his LLM with someone in London, 20 years ago, whatever it was. And very good guy, very much understood the limitations of investment law. We shared a lot of points of view back then. And he went on to practice investment law because, he needed a job and he represents states quite a lot. And I visited him once at his firm in a major Western European capital, I'll just say. And it was he was hosting. He took me around the firm. He introduced me to prominent investment lawyer. It was a pretty frosty exchange because my reputation preceded me. And he took me eventually to the boardroom of the firm. Beautiful room. The table was just so impressive. I was complimenting him on the table, the ceiling. It was just gorgeous. He said to me, no, Gus, you don't understand. This is the room where states come before you and they kneel. Make of it what you wish. So are there any other questions or comments? Yes, please. If so, I see some hands. Please approach the microphone. Don't run too fast, but it will, yeah. Go ahead.
Yeah. So my question is that like with regards to investor agreements, don't the agreements between countries or the companies who are often in like the global north often internationalize their own domestic laws, which then, because then those governments or the companies wouldn't even have the authorization to make those deals in their host country, in the first place, because the governments themselves are also bound by certain laws. And then if that's the case, given that those same countries, there's also like tons of civil litigation, particular precedent in the environmental and health areas, which are adjacent to human rights. There's of course the Dutch case, which was based off the European Court of Human Rights, the Inter-Americas. And then, so isn't then the problem then we just need to see more litigation with regards to investment treaties, rather than the treaties themselves don't implicitly already carry those human rights obligations?
Okay, great questions. I'm going to take a couple more questions and then we'll go to the panel members. Yes, please.
So my question is in conjunction with this one. Actually, it's a two-part question. So firstly, I think as far as IIA's ISDS mechanism is concerned, I suppose most of the global north companies or global north countries generally have already taken advantage of it. So now when the tables are turning, especially from global south investment going to global north and investment companies going there, something equivalent to perhaps something I would know Adani Industries. Adani was planning to actually take the route of investment arbitration as well in Australia with what they were doing. So isn't it perhaps a harsh word, hypocritical on our part to sit here and discuss this when this has already happened for 15 years by most of the global north countries, and now there have been quote unquote sustainability impacts because the global south companies are now providing investments in global north countries and doing the same thing? And the second part of this is that, does this impact the trade agreements? For instance, India and EU are right now negotiating a trade agreement as well. And the EU wants India to actually put forth human rights and sustainability clauses in its trade agreements, which of course, India has rejected because it's just not possible for most of the global south countries. So does this also impact the FTAs? Thank you.
Thank you. Let's take, why don't we just gather all the questions and I'll let the panel members respond as they prefer. So please go ahead.
Hi there. My name is Jen and I make angel investments into climate tech companies. However, there's some investments that I've wanted to make that I haven't been able to because of Canadian regulations with the OSC. While most countries in the world can make these investments, we as Canadians cannot. One of the examples of laws that relates to it or regulations is the investors not having a minimum amount of skin in the game in the case of a syndicate, while meanwhile, these investments are going alongside large lead investors. And most people in the world who are accredited can make these investments, but we as Canadians cannot. So my question is, how can not just Canada, but other places make it more accessible for people to make investments into climate tech companies? Thank you.
Okay. Thank you very much, Jen. And one last question.
I'm a Nigerian, and Segulala is a mining company in Osun State, Nigeria. And the major shareholder in that company is Thor Exploration from Canada. So we've had complaints about environmental practices and all of that. And I recall that you just mentioned now that there is a table where states go to beg. And, practically, this probably has happened in Ocean State, Nigeria. So what you would see is state governments begging these exploration companies to come to their state, and then, revenue will be structured. But, some things would happen, state governments wanting some certain part of the deal. My question is, so we've had this conversation about, bilateral investment treaties, human rights explorations, community rights, giving them standing to sue. But when you have a situation where states are so invested in these exploration companies coming to that community for whatever gains, revenue and other gains, how practically enforceable would it be when you give, let's say for some reasons, communities then have some standing, there would be some antithetical interest between the state as we know it and the local community. What is the practical enforceability of these options, if ever we get to have them? That's my question. Thank you.
Thank you very much. Would anyone on the panel like to pick up on any of those questions first?
Okay. Shall I start?
Thank you, Anil.
Okay. Thank you. I don't know actually very much about climate tech investments in climate tech and different types of investments. So I don't know if I'll be able to answer that question in an informed way, but it is an interesting thing to hear that there could be some barriers from the home state, let's say in this case, to investors making investments into certain, climate action-focused investments. So I would like to know more about it, but I don't have an informed answer to your question. Apologies for that. So there was a question about, I guess, the hypocrisy of the global north now that they're being targeted in these investment treaty claims. I think if I didn't misunderstand that question, that they're more interested in introducing sustainability clauses or clauses that relate to kind of these public interests. And that I agree with that. But I think we can get whatever we can get. Robert last night was giving advice about taking the long view. And that's, I think, what we need to do, to take the long view about, whatever gets us to the point that we want to arrive at. Not whatever, but I think it's still beneficial to this debate that global north countries are interested in this. But again, the merits of what is being done in terms of reforms aren't, I think, strong enough anyway. So that is quite problematic. And the last question about this tension between states and local communities and investors in local communities. I mean, I'm going to leave you to talk about that, but I often think about this when I think about investment treaties and investment treaty reform, that there is this focus on this binary relationship. We need to expand the states' room for regulation. We need to give more rights to states. We need to give more obligations to investors, but there is very little focus on this tension between communities and states. States are often the oppressors. We have international human rights law, obviously, to rein in on that to some extent. But I think that is a thing that's mostly missing from the debates, except for some of Nicholas's work, I think, and a few others. And it's really important to reintegrate that into the discussion.
Thank you.
Okay. Well, thanks for the question. First on the hypocrisy point. So just two negotiations, one in the early 1960s, one recent, concluded 6 or 8 months ago. So the state that was on the global south, quote unquote, developing state, was fine with investment protection for whatever reason, maybe badly advised, but still. But they did ask for something to ensure that investment was going to contribute to development. I can tell, so for instance, the recent one, it was performance requirements, technology transfer requirements, linked to climate change, research and development requirements, and the capital exporting state said, no, well, in this case, it was not a state, it was you can guess, not a state, a number of states, they said no. And this happened also in the 1960 thing. So I think the hypocrisy operates at two levels, in my opinion. One is that we are telling states in the South that they need to attract investment to get to development, but we're not giving them the tools to ensure that that investment is going to turn into development. And we know because of economics, I mean, Roderick, Stiglitz, that it's not like you just add investment and everything's going to be well. So I think that's a problem and still a problem today. So that perhaps I think that the obligation side to me should not be focused only on human rights, but also needs to take into account the development dimension. And the other thing when it comes to that, so I agree with Anil, but I have this intuition, I hopefully wrong, that once you get the pressure out of the US, Canada, and the EU about the problems of ISDS, that people are going to forget about ISDS. I mean, particularly civil society in Europe, the US, and Canada. So the system is going to go back to only countries in the South being hit. And this happened for many years, and ISDS was not a big issue if it was not for Canada and NAFTA. So what if the cases are there were important cases in the 1990s against African states that, if you read those awards, basically the arbitrators were saying, but if you don't have a legal system, what can you expect? Are we going to go back to that kind of thing? Hopefully we won't. And that's the only thing I'm a little bit scared about. On the political economy, only to add one thing, I agree with what Anil was saying, is if you take post-colonial studies and the way states operate, and Shalina Randeira, for instance, she explains that most global South governments are elite governments that have close relationship, with business, sometimes in the global North. So, there is a problem there. I think, Sandhya has done a lot of excellent work on that. And what the state is, how the state was co-created by international law. It's not that the state is randomly there operating in the way it is operating. International law also contributes to that. So maybe instead of thinking that, what can we do for, communities to have standing in investment treaties, we should think how we can make the states different. And not, decolonize the state if you want to.
Thank you. Maybe I can answer the two questions that, if I counted correctly, have not yet been addressed. The first is this idea about internationalization of domestic law in investment arbitral tribunal proceedings, if I got that correct. This is an idea that's been out there. And the question is, of course, well, why don't the arbitrators or the states or the treaties actually read more domestic law into it? What we can see is that the tribunals would basically say, and this is actually what investors also say, just decide the case based on this treaty. Don't say something about domestic law. So basically they are saying, well, fair and equitable means blah, 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 and this was not met in your case. And states are also very reluctant and I think we heard this on a panel before, states are very reluctant in actually inviting in the arbitral tribunals to interpret their domestic law. So I think that's one of the arguments why we don't see that. And I would actually be very careful in advocating for that. We've seen that in other legal systems. What happens if international courts or regional courts start interpreting domestic law? You get all sorts of very strange reactions. And I think before you advocate for that, we would have to reform the system in a very, very different way. The second question, which I think was not taken up yet, is what impact will that have on free trade agreements, specifically the one the EU is negotiating with India right now? I think that's a very interesting question. And what we're seeing actually is that at least the EU, this is the entity that I can speak a little bit about it. They still have this idea that they come to the negotiating table, firstly, as the country and the market that, of course, everyone wants to have an agreement with, which is in many cases wrong. And second, they come to the table with this idea, our legal system and our ideas of reforming everything are the best ideas anyway. which is also wrong in many cases. And so I think that I hope at least that many of the Commission negotiators are currently learning it the very hard way, that saying, we put sustainable development in there, but we also want to keep investment protection. And of course, we want to reduce tariffs. And no, you cannot protect your agriculture. And of course, you need to have patents with only 20 years protection, which apply to medicines and stuff like that. That's not going to work anymore. And I'm just not sure whether Europe will wake up soon enough to realize that this model that they've negotiated trade agreements in the past is actually no longer working.
Thank you very much, Marcus. Our time has come to an end. I'd like to thank the members of the panel and everyone who posed questions, and apologize if we didn't get to every facet of the question. I do apologize. So thank you all, and enjoy the rest of your day.
Okay, so welcome to the third panel on corporate law and sustainability. I'm Martin Petrin. I'm a professor at Western University, and it is my pleasure to be chairing this panel with four scholars that I can honestly say I admire very much. And we have Carol Liao. She's professor at UBC's Allard Law and the Sauder Distinguished Fellow at Sauder School of Business. She'll be talking about complicity of corporate law and future possibilities. We have Per Zambunsen. He's the inaugural professor of business law at the Faculty of Law at McGill University. His paper is Corporate Law, Sustainability, and the Anthropocene. We have Christopher Brunner, who is the Stembler Family Distinguished Professor in Business Law at the University of Georgia. He'll be talking about corporate governance and sustainability incentives. And then we have Lorraine Talbot. She's Professor of Company Law and Context at Birmingham Law School in the UK. And her title is Growth and Degrowth Attributes of Corporate Capitalism. So join me in welcoming them, and thank you so much.
Okay. Thank you, everyone. Thank you so much, Martin. Thank you, Barnali, for the invitation. And thank you to my fellow panelists, old and new friends, for what I am sure will be an engaging time on this panel. I have to say, I struggled a bit in deciding what to speak on today, given the range of things that one can say on corporate law and sustainability. And when I narrow my focus to corporate law specifically, it feels accurate to note that the field of corporate law has been quite complicit in this climate catastrophe that we are finding ourselves in. And as the world has increasingly warmed, so has its potential to burn. I put in the background of my title page here a recent picture from my hometown in Vancouver, where the summers are increasingly hotter. In my province alone, we've seen raging wildfires, smoke-filled skies, heat domes, towns evacuated and decimated. And the last 2 decades saw the highest increase of greenhouse gas emissions in human history. And the last 8 years have been the hottest on record. And we cannot follow the same pattern if we're to hold global warming to 1.5 degrees. So I start then with a quote. Dr. Jane Goodall, who said, "We are the most intellectual creature that has ever walked planet Earth. How is it possible that we are destroying our only home?" And I think it's important that we keep this question from Dr. Goodall in our minds, because we need to remember what's at stake. So first, very briefly, in corporate speak right now, when you think about sustainability issues, the term du jour, which hasn't been mentioned thus far, has been ESG, standing for environmental, social, and governance. And it's a concept that's been around for a while, but what we've seen is there's been a rapid acceleration in prominence over the past few years that's shifted the baseline and had ripple effects in terms of expectations from stakeholders and investors in particular and others. ESG as a term is used to assess an organization's behavior and evaluate its performance based on those companies' risks and opportunities. And whereas CSR, which Dirk earlier mentioned, tends to be viewed as this optional, voluntary, and external-facing type of activity that's very susceptible to greenwashing and certainly justified skepticism, ESG seems to have this different tenor to it. And so now, in terms of the consideration of stakeholder interests, That has always been relevant under Canadian corporate law. So I feel the need to very briefly clarify that, particularly when we have our international friends here. While not spending too much time on the point, in Canada, boards have fiduciary duties to the best interests of the corporation, viewed as a good corporate citizen. And in making their determination on what those best interests are, directors are to consider the interests of, among other things, not just shareholders, but also employees, creditors, consumers, government, retirees and pensioners, and the environment to inform their decisions. There are particularly also a number of stakeholder remedies that are available in Canada. This is all to say, in Canada, we have very well-suited governance structures for companies to infuse ESG in their corporate decision-making. And from a legal risk perspective, it would be very wise for boards to all adopt ESG norms as a wide variety of stakeholders are increasingly demanding this information. So organizations need to think about what ESG issues are priorities for their organizations. It's a broad concept that continues to evolve and can change over time. These terms also tend to have a bit of a shelf life, but climate-related risks at this point span all industries. But otherwise, what ESG means can vary in importance across different sectors. What is the E? What is the S? What is the G for the company? And it could range from, of course, human rights, board diversity, relationships with Indigenous communities, biodiversity loss, anti-corruption, global supply chain management, cybersecurity, executive compensation, you name it. Now, I co-lead the Canada Climate Law Initiative. And two of my lovely principal co-investigators are here too, Barnali and Sarah Gebramuse in the room right here. CCLI is dedicated to advancing director knowledge on the latest in climate science and fiduciary obligation. And I'm proud to say also CCLI has clearly clarified and settled any debate in Canada on whether climate governance is a part of a board's fiduciary duties. The CCLI has commissioned legal opinions from well-respected lawyers in Canada, confirming that directors are obliged to be proactive and critically evaluate and address the material risks and opportunities associated with climate change. Now, these are legal opinions, as this group knows. That's not an op-ed. That's not a Twitter thread. It means they're providing their legal conclusions that allow the recipient to rely on that opinion. And what that also means is that having a climate change denier on your board is not reflecting a diversity of perspectives. If they are to act on that belief, that director is reneging on their duty of care to the corporation. These legal opinions are publicly available on our website. Just a second to shill for CCLI. We also have recordings of over 75 events and webinars we've hosted on climate governance. We have 22 sector-specific reports, executive education programs. We have 7 of them with, to date, 173 board presentations delivered to over 1,500 directors on climate governance, resilience, and risk specific to their particular industries. To date, the CCLI website has had over 15,000 site visits and over 4,500 report downloads. And so to unpack some of the information that we provide here for you, here is what boards and scholars need to know moving forward in this changing governance landscape. First, material risk has always been something that companies have had to report, and there is a global consensus that climate change is a financially material business risk. Climate change differs because of the systemic and interconnected risks that can act as a risk multiplier, and these risks are not diversifiable. The regulators have acknowledged that you cannot create a portfolio investment that will allow you to avoid these risks. So per the Task Force on Climate-Related Financial Disclosure, physical, acute, and chronic risks can cause direct damage to assets, operations, global supply chains. They increase costs, exacerbate employee safety, etc. Transition risks to a low carbon economy can be driven by changes in client, consumer, investor behavior and preferences, changes in government policies, unanticipated write-downs in carbon intensive industries. It includes liability risks for failure to disclose these material climate risks to clients, to investors and stakeholders. So it is quite urgent for boards to be strategic in their deliberation as to how to enhance climate resilience. So climate change is forcing fundamental shifts in how businesses operate. And as a result of these risks, we are seeing the rapid implementation of climate disclosure requirements around the world. And what I really want to convey here is the significance of what is changing and those ripple effects. The federal government has issued a number of measures aimed at achieving a net zero carbon economy with the promise of bringing mandatory climate-related disclosure in line with the Task Force on Climate-Related Financial Disclosures, which OSFI, the Office of the Superintendent for Financial Institutions, the bank regulator, has also endorsed. So what that means is that climate disclosure is increasingly becoming an access to capital issue, something you can tell your business students. Companies, whether they like it or not, are going to have to understand what Scope 1, Scope 2, what Scope 3 greenhouse gas emissions mean. If you don't know that now, we will very soon. And we'll need to be able to upskill to understand these rapidly evolving regulatory demands and how to adapt. Courts around the world, and this has been sort of echoed earlier, said earlier, they're increasingly affirming the scientific evidence on climate change and that its harmful effects are reasonably foreseeable. Right? And entities producing GHG emissions can be held responsible for failing to sufficiently reduce emissions. There is a tidal wave of climate and ESG related litigation happening worldwide with over 2,700 cases and landmark cases that are just frequently altering the corporate legal landscape. And more than 170 countries have introduced national policies and laws on climate change, mitigation, and adaptation. What we're also seeing are that plaintiffs are really willing to try new, creative, and innovative legal arguments when it comes to climate across the court system, across administrative tribunals and non-judicial bodies, including using plain vanilla tort liability. Some are even willing to take on cases when the prospect of winning is limited. So climate litigation isn't going away, and lawyers in particular are going to need to understand this evolving space. So a lot is happening, and our team at CCLI is working hard to advance climate governance education across Canada. But I do want to note something in this opportunity of having this intellectual space to discuss these things. The CCLI is trying to combat misperceptions in the law, right? But we are also bound by laws that are colonial in nature and do not integrate stewardship or sustainability in their systems, right? We are disseminating what is now a reaction in corporate law, measuring the risks put upon the corporation. Our finding is that climate change is so bad now that boards have an obligation to put climate on the agenda. Canadian corporate law to date has been largely unable to respond to the regulatory gaps that arise from these really wicked, complex, and difficult Earth system challenges. You know, the IPCC, the Intergovernmental Panel on Climate Change, observes that one of our greatest challenges is the governance capacity of institutions to develop, implement, and evaluate the changes needed within diverse and highly interlinked global socio-ecological systems. And that it's policy arenas, governance institutions, and robust structures that are key enabling conditions to transform, for transformative climate action. So, you know, there's no doubt at this point that the scientific consensus exists on the issue of climate change, right? The debate is no longer about the science. It's on values, culture, and ideology, and for us, corporate norms. And I don't think I need to convince anyone here that our mental models are being seriously challenged by the complexity, the scale, and the speed of climate change, and our existing approaches are increasingly failing to tackle these challenges. And as we most experienced from this pandemic, the twin crises, I find, the level of global interconnectivity was, a reminder, and that interdependence of the economic systems has revealed some really deep vulnerabilities, not only in relation to contemporary capitalism, but our societies. And corporations, the thing is, they're complete creations of the law, right? And they rely on the law for their existence. So you would think that they would be directly accessible for regulation. And I saw this comment kind of echoed in the previous panels as well, which is that contemporary business practice is characterized by deep complexity and opaqueness. I teach my students about limited liability, asset partitioning, control and governance, decoupling, financial engineering, all factors that have really, really dire impacts for regulating business to achieve sustainability because of the difficulties and in some cases, the impossibility of identifying who or what is in control. Corporate law has allowed for the fragmentation of accountability. So it's essential that law and policy integrate the realities of corporations' unsustainable practices. Now, yesterday, Robert mentioned the Corporate Due Diligence Directive, and I do look towards Europe's adoption of a whole economy approach as a hopeful one that pushes corporate law forward in a way that I wish we would do here. And I know Per's going to be talking about it in more detail. So just very briefly, companies are to prepare for sustainability reporting in accordance with uniform standards. And with this implementation, in a first step, the sustainability requirements are directed at the companies in the real economy, where they need to produce a report with information necessary to understand the company's impacts on sustainability matters and information necessary to understand how sustainability matters affect the company's development, performance, and position. So companies must comply then with this concept of this principle of double materiality, which in a nutshell means companies must not only inform about those sustainability matters that impact the company, which we call this financial materiality, but additionally report on the company's activities that may have an impact on the environment or on third parties, which we call the impact materiality or environmental and social materiality. Now, together with their taxonomy regulation, their sustainable finance disclosure regulation, a bunch of other ones that are above me in the alphabet soup of this package, it's going to be terribly difficult for a company to greenwash. And I think that holds some very merit-worthy developments internationally in corporate law that are much need for Canada to maybe look at and consider. I'll just end by saying Canada's warming at double the global rate. And due to time, I'm not able to delve in a lot of things I want to talk about more in it, but that includes the obvious links that climate change has with human rights and equity. And, touching upon what has been said earlier about that and that theme. But I'll note very clearly that climate change, there are disproportionate impacts that climate change has on Indigenous peoples and their territories. And so in addition to the UNGP, UNDRIP may need to play an important role going forward. The effects of climate change also have racial disparities. There are gender differentiated impacts. There are disproportionate harmful effects on the global south, on the poor, on children, on people with disabilities, and the most marginalized in our communities. So, earlier this week, I was saying to some dear colleagues here that I was at this very intensive 3-day retreat with climate partners from across the country, led by the Ivy Foundation, sitting down in all sincerity to plot out how we can get our resource-rich nation to a net zero carbon economy as fast as possible and do our small part in the world to help stave off some of the worst of the planetary tipping points in this climate catastrophe. It is a difficult conversation, but one that has to continue, particularly right now. We do need to chart a viable path forward in Canada in clean energy and a just transition, while understanding the rapidly evolving laws, regulations, expectations, the importance of Indigenous sovereignty and empowerment, and the trajectory of the law going forward in the Anthropocene, and how we think about risk and opportunity. And certainly corporate law has a role to play. And there are many policy proposals CCLI is pushing forward to help make corporate law not a complicit actor in this climate emergency. And if anyone wants to ask me about that, I'm happy to during the questions. But these proposals are very vulnerable right now due to the looming federal election everyone is predicting will happen next year and where that will land. And it's not looking good. We are living in the age of dissonance, in the greatest tragedy of the commons. And in the immediate future, we're going to need to see the greatest collective action we've ever seen in the history of humanity. And we can't shy away from these hard conversations and think about the goals we're setting for ourselves and to continue to press on while making the business legal, and most importantly, even though it's always seemed as a tag on, the ethical case for ensuring sustainability and that there is corporate accountability as we navigate in this increasingly warming world. Thank you very much.
Thank you very much, everyone, and thank you for the invitation. It's really lovely to be back at Osgood. I almost wanted to check whether there was any mail for me, although I left years ago, but I don't think there was any. All right. Now, these are not my slides.
Yeah, sorry. I
Don't worry.
Slides in case.
Yes, I know. That's good. Okay, that's mine. All right. So we didn't coordinate any of this, but as you will see, I hope it fits nicely together. I want to complement what you just heard from Carol by taking a bit of the breathlessness out that I feel now, and by trying to give a bit of historical context. And the reason why I want to do this is because if you do any of this work, then there are two sentiments I think that happen. One is that you don't know where in the river you're actually stepping into this story and how much already has happened and why things seem so obviously wrong and bad, and why they haven't been fixed, and why we operate with dualism still. And if you get into this debate at the current moment, you still find that there's a strong emphasis on shareholder value maximization. And then if you care to do just a bit of history, you find that that's been going on for decades. And you think, how can that just be if it doesn't explain very much? The second sentiment is that there's such a sense of urgency now that you wonder how to make sense of this overwhelming account that you just heard of how much litigation happens, how much legislation is happening, how strong and how hard soft law seems to be becoming, how many actors, public and private, international ones, are involved in this. And at the same time, we still wonder whether ad hoc, individual interventions, repairs could do the trick, or whether there should be an overall reform. And if I were young now and I would step into this debate, I would just find it debilitating and overwhelming. And it's a bit strange why that is. So my teachers in Frankfurt, they won before the Federal Constitutional Court for the law of codetermination. And codetermination, as many of you know, it's seasonally recurring as a reference point of how one could have a more inclusive and a more balanced governing of the economy. It's almost a cliche now that German companies, as of a certain scale, have a supervisory board with worker representation. And for a long time, nobody really cared about this. And after the hard battle in Germany over whether the government would be allowed to make this intervention, things actually settled down and it's become established. But then you read accounts, not just by Christopher Brunner, but by others that, of course, say even in the heartland of Rhinish capitalism, such as Germany, where you have a codetermined board of large stock corporations, you have the Volkswagen scandal. That could still happen. Why didn't the workers see that? So there are paradoxes. What I want to invite, especially younger ones, is to somehow try not to get so caught in this either or and in the breathlessness of those debates, because the the decisions one made already a long time ago, they are so determinative of where we are now that it's naive to think we can just undo that, because it's such a structural condition now in which we have commodified and I'll get into the detail. So we have so many things that are so difficult to change ad hoc that the debate, especially when you go to the US and you get caught up and waste your time with dealing with anti-woke legislation, and it's just terribly energy consuming, that one has to maybe look at this more broadly. Okay, let me try to do that. So I'll now go through 3 steps quickly, and already now used for setting the stage 4 of my precious minutes: causes, anatomy, and interventions. Okay, so the causes, you already heard a lot of that. They are entrenched in the way that I think the last 20 years or so, we've basically accepted that the state shall not intervene into market relations in a mandatory and strict way, but rather focus on disclosure. And that was unfortunately the outcome from the 80s and 90s, where markets, and we actually believed that for a while, we could shame market actors, we could name their aberrations and their missteps, and we would shame them into different behavior. And that actually didn't really pan out. We also, I think, over a very long time accepted that corporations are sacrosanct and that they are the drivers of an economy. And so we should accept that law that governs it, not just corporate law, but the entire legal infrastructure, is enabling and not intervening and actually steering how corporations are run. And of course, there's very deep roots to that. So to change it doesn't only in the US create a huge backlash and concern, because you touch at fundamentals of liberal market theory. But then at the same time, you find more and more evidence of scholars that say there's something seriously deficient in the way we focus on disclosure rather than mandating structural changes within corporations. And if you look at this literature now, and there's so much of it that's actually difficult, especially if you're a student, to actually understand, like to map all this field, but it's very frustrating. And you can sense that there's a strong sense of resignation among many of us. All right. Now, if one wants to reconstruct a little of how one got here, then especially if you're young, you wonder, why would it be important to retrace some of these steps? But the steps from CSR to ESG are actually quite important, not just to relive a sad history and see whether ESG can make up some of the deficiencies that we schlepped all along CSR, but also to understand that CSR responded to a particular understanding of who is vulnerable and how do we understand political economy that took very, very long to critically unpack. And that still is owed very much to the understanding of how we see private actors and private power and the role of states in regulating private power since the early 20th century, because we focus so much on workers. And if you try to make sense of UN guiding principles, then it also makes sense to look at the ILO and say, how has the role of the ILO and the struggles of the ILO in Geneva across the 20th century made us stuck in this tripartite structure that keeps focusing on employers, employees represented by unions, and the government. And the ILO itself and unions at the head of that, fighting against the diversification and pluralization, not just of vulnerable demographics, but also of non-directly labor-related interests, which also means that the ILO was marginalized. And that, of course, then contributed to the way in which we delayed a much more enlightened approach. All right. Then there's tons of literature that I think is important to recognize if you want to know when you step into this river of how corporate theory has been evolving over time. But the report card is relatively negative. Everybody just comes to find that they are lacking in some part because they're just perpetuating certain biases and cliches. But all of that is still important to take into account. And then it comes to this important time of the 70s and 80s. So many of us writing about this make references to financialization, and we manage, some of us now, to write just 1 or 2 sentences to explain what it is. But it's quite tricky to undo financialization. So it's not just that you can say, I would like to go back to the dualism between Karl Polanyi and Hayek, writing at the same time 2 very different books. One, Polanyi worrying about the liberation of markets from political control, and Hayek saying that's exactly what should happen. Because now in the 70s, we create a situation in which states have invested so much in making law a facilitative enterprise for investment that has changed not just the flow of capital into national political economies, but it has changed the entire structure of welfare states. And because that's been going on for decades, it's very difficult to pinpoint that we now focus on corporate law and its neighboring disciplines to undo that and to change it, because we've already neoliberalized the political economy as such. And that has happened, unfortunately, nationally and transnationally. That means if we now add climate change and this breathless urgency and debilitating specter of it to that, it feels as if we now need to find solutions right away. But we already think, well, we've been doing this for so long. Why hasn't anything changed? And so when I read now scholarship from the last few years, and people make references, sometimes a paragraph or 2, to varieties of capitalism, or to the John Ruggie, the same guy that did the UN Guiding Principles in the 80s, writes a really famous article about the end of embedded liberalism. It's one of the most important articles, I think, to capture that transition. These people go back to this and they say there was something that got lost. And since then, we've had too much market liberalization in the state trying to catch up, or actually facilitating that these developments continue. But if you actually were to slow down, and even if it's just one day, and you actually reread what were the stakes of what Ruggie described, and what was the lost political agency at the time, and where would be the points of intervention where we could rebuild that kind of agency, then you think, I think, in a constructive and less breathless manner about which political pieces to mobilize. And that's, for example, why I highlighted Banali's suggestion earlier from that article. If one says we should diversify boards, then that is either in the realm of corporate self-regulation, we try to make it public on how well companies do it, or we actually say it's not just, a little incremental change that we hope they go along with. It's a retaking of political agency to say, we learn from ethnographic work, we learn from some of the really big cases in the UK of how much ethnographic knowledge has gone into consideration of how mining impacts communities, that we could translate that knowledge out of the courtroom into legislation and say, that requires companies to have representatives of affected communities on their board. I managed to hide my telephone. That's really good. And so it's actually not difficult to do that, but one somehow runs too fast. Okay, I have so little time left. Second element of earlier times is varieties of capitalism. So for people that enter this debate right now, it's almost difficult to relate to it because it seems to have come at some point and just gone and didn't leave a trace. So that political economists were working for a long, long time to focus on how are the roles of government and public actors different between so-called liberal market economies and coordinated market economies isn't just a historical fact, but it returns to a time where you could, in fact, try to re-energize a coordinated market economy, rather than just accepting that liberal market economies are the end of history and that's just the best we can get. It's at the same time important to revisit that literature and find that some of their proponents were hopelessly social democratic. They were hopelessly invested in nationally confined economies. They were lamenting the erosion and the destruction of the welfare state. And because of that, they fight this war against the evil shareholder value maximization. At the same time, they miss opportunities to look at what the new actors, norms, processes are through which one can rebuild political economy. The Bangladesh Accord, we fight, some of us fight 10 years against public lawyers and labor lawyers who are of that variety of capitalism background that say that's all not law. We don't want that. That's just, I don't know what it is, but it's not law. Unless we begin to say, no, those are grassroots, bottom-up, new forms of lawmaking to which we can actually start to apply different forms of rule of law measurements. Okay, lastly, there's tons of, as you just heard from Carol, tons of work happening in terms of standardization of disclosure requirements. The introduction of the so-called double materiality standard is completely overwhelming, but it's supposed to come into force in 24. Now, if one goes more slowly and says, how have we built the knowledge base for understanding what the footprint is of corporations, then you can actually find that we have done a lot of work on impact materiality. We don't have to reinvent that really. If you read some cases like Vedanta or Begum in the last few years, you find that all of this work already has been done. We just use it too little. Okay, lastly, for lawyers, specifically, the case law that's evolving right now in Delaware around the so-called care mark standard is extremely important for us to look at, because there's a strong push to use the breach of fiduciary duties by directors for lack of oversight of how the company is in line with positive law, how that can be pushed to include double materiality, specifically impact materiality, as a critical mission critical element of what the directors of a corporation have to supervise. That's seemingly technical, and it's also not all evident that it's going to be easy to include climate risk, because all of this focuses on the violation of positive law. But if we're able to push the solidification of UN guiding principles as it manifests itself across so many countries that make supply chain laws now, it's not such a big leap to say this is actually positive law. We just have to be not creative, but we have to work very hard to show all these norms as they evolve and say they materialize that standard that Delaware courts are struggling with. Thank you.
Okay, well, thank you so much for the invitation to be here and for these fantastic discussions. It's really been fascinating. I'm a corporate lawyer. I was saying earlier to fellow corporate lawyers that I don't get out of my corporate governance rut enough and get to these meetings where I'm encountering folks who are working on similar problems from other disciplinary and doctrinal perspective. So it's really been a pleasure. Like the rest of you, I've spent a lot of time generally thinking about this topic of corporate sustainability over recent years. As the American on the program, it saddens me to report that as I survey our domestic landscape through the corporate sustainability lens, the outlook is bleak. I increasingly find myself concluding that the American sustainability reform agenda, such as it is, remains fundamentally broken. The reason, I think, is that we've basically held constant all of the deep structures of the corporate form and corporate law that lead to excessive risk-taking and externalization of costs, and then just sort of layered on top a few light countermeasures that are sufficient to invite us to pat ourselves on the back for having taken action while in fact having changed nothing at all. Now, my paper is a call essentially to expand the terms of the debate, to broaden the scope of potential reforms on the table, and to revisit fundamental corporate structural features to incentivize more sustainable governance. Now, specifically, I'm going to focus on decision-making incentives that emanate from these structural features of three sets of actors: shareholders, managers, and workers. The paper critiques those incentives by reference to their compatibility with corporate sustainability, understood broadly to include environmental, social, and economic dimensions, and suggests more fundamental reforms that I argue could move the dial without gutting the benefits of the corporate form, as many fear. This will pick up on themes that we've heard already on this panel and that we've heard in earlier panels. And I'm going to focus on Delaware, the legal home for most U.S. public companies, which we could take as a sort of comparative benchmark in the spirit of a high watermark of shareholder primacy or something close to it. Now, bizarrely, the incentives of shareholders have largely been ignored in reform discussions, even though most corporate governance theories place them at the heart of the action. As we look at the corporate form today, this is not true historically, but as we look at it today, perhaps the foundational reality of the modern corporate form is that limited liability incentivizes shareholders to favor a lot more risk-taking and at the same time to avoid any real confrontation with the consequences. Now, to understand why, we could simply take the law and economics account on its own terms. As Easterbrook and Fischel explained, shareholders with limited liability capture the upsides of corporate risk-taking, but largely avoid the downsides, which leaves them strongly predisposed toward greater risk in order to generate greater returns. Meanwhile, any practical need or incentive to monitor management is sharply reduced because, again, shareholders bear only limited downside exposure, and they can further diversify their investments in order to reduce exposure to idiosyncratic risks, which has the effect of disengaging further from the real-world consequences of the wider portfolio of corporate operations that diversified portfolio now finances. Now, to the extent we can imagine any discipline involving shareholders on this account, it emanates indirectly through the capital markets from the market for corporate control, which implicitly substitutes stock price as the performance benchmark for whatever might have actually guided shareholders' decision-making themselves if they were actually forced to confront the consequences of what the business is doing. This disengagement then has been worsened by the intermediation of investment, which further distances shareholders in a couple of ways. First, through the insertion of opaque fund structures, which make it hard for anyone to know what their funds are actually invested in. And then by handing over decision-making power to intermediary fiduciaries who are either duty-bound or at least feel very strong pressure to maximize returns to the fund. Now, these incentives all flow directly from limited liability, but they're reinforced by other features of corporate law that further incentivize shareholders to act, to the extent they engage at all, as profit maximizers. In the U.S. system, shareholder litigation is typically spearheaded by an entrepreneurial plaintiff's bar, focusing on a couple of things. Either they're focusing on premia paid in the context of fundamental transactions for purposes of derivative suits under corporate law, or they're focusing on stock price drops following revelations of bad news for securities suits. Now, in this sense, we might style the plaintiff's bar as another intermediary that essentially kicks into gear to foster shareholder action only when there's been a perceived failure to maximize short-term returns. These dynamics then are reinforced by the perceived normative underpinnings of these fields to the extent that market actors at least believe that corporate law requires shareholder wealth maximization and that securities law prioritizes disclosures that would be relevant to financial investors. So what about managers then? Through this lens, a lot of corporate law becomes comprehensible as a means of operationalizing strong form risk-taking along the lines that shareholders with fully limited liability will prefer. Insulation from care liability through various types of structures performs this function, freeing up managers to pursue the risks that shareholders are presumed to want. The resulting managerial incentives are strongly reinforced then by various features of corporate governance that favor shareholders and their interests. Managerial decision-making is naturally going to skew toward shareholders to the degree that the corporate objective is framed in a way that prioritizes their interests. Now, although the degree to which the corporate objective remains fettered to shareholders has been exaggerated, even in the United States, various structural features of corporate law reinforce managerial focus on shareholders, notably derivative standing and voting rights for things like elections and fundamental transactions. Various market dynamics then further reinforce all of this, notably the market's assessment of performance over short time horizons, which reflects a shift over time toward relatively shorter investment holding periods. modes of financial accounting that focus narrowly on shareholders' equity in the context of the balance sheet or in bottom line profit in the context of the income statement, without regard to environmental and social costs, and structures like equity-linked pay, which obviously aim to align managers' incentives with shareholders further. So what about workers then? Workers' incentives, as we've already started to hear, vary considerably from one jurisdiction to another because there's enormous variation in how their role is conceptualized and the degree to which this group overlaps with shareholders and managers. Despite their centrality to economic theories of the firm, lots of jurisdictions conceptualize workers as outsiders who effectively deal with the company solely through arm's length contracts, which implicitly places their interests outside the scope of corporate law. In those sorts of cases, workers' incentives are conditioned by this reality and strongly skew toward security and stability, reflected most directly in corporate law terms in the context of fundamental transactions like hostile takeovers, where their stability interests closely coincide with managers, which at least in some jurisdictions, including Delaware actually, lends some normative force to use of defensive measures. Now, at the same time, workers' incentives can be complicated by other structures. To the extent workers are themselves shareholders, say through equity-linked compensation or pension schemes, this presumably shifts their incentives towards shareholders to some degree. In other systems, meanwhile, as we heard earlier, workers are treated as structural insiders, most obviously in co-determination systems, which introduces more direct capacity to participate in management. Now, stepping back from all this, it's critical to acknowledge that sustainability-oriented reforms, at least as they've been pursued in the United States, haven't really meaningfully responded to these core incentive structures. In fact, they may have reinforced them. Imposing sustainability disclosure requirements, often limited themselves by reference to financial materiality, has to date yielded little in the way of useful information, but it's cultivated the pleasant illusion that something is being done. Similarly, opt-in social enterprise forms, I would argue, may do more harm than good. The Delaware framework, for example, doesn't empower non-shareholder constituencies to do anything, to enforce any public goals. It really just gives boards a limited shield against myopic shareholders who remain the only actors under these structures who actually have derivative standing to advance claims in the company's name. Now, as was alluded to in an earlier panel, a very small percentage of entities opt into these structures, but their very existence creates the negative and false implication that standard corporate law permits no discretion whatsoever to bring non-shareholder interests to bear upon corporate decision-making, which only reinforces the shareholder-focused incentives that these structures are meant to change. The reality becomes, if you want to be free to maraud the earth, all you have to do is not choose to be a public benefit corporation. Meanwhile, existing ESG pay structures have typically weighted sustainability-based components so much lower than stock-based components that the results empirically have looked more like a greenwashing exercise. Now, at the same time, as we heard just a few minutes ago, it's important to acknowledge that introducing workers' incentives directly into the corporate governance mix, although perhaps desirable for lots of reasons, isn't obviously a panacea for all corporate ills. There's certainly evidence that this improves social and perhaps economic stability, but companies with substantial worker governance still experience problems that seem to reflect some degree of shared incentives favoring relentless growth and willingness to externalize costs to the environment, the Volkswagen emissions scandal that we heard about a few minutes ago being a vivid example. Now, to the extent these problems stem from the incentive structures that I've just described, the question becomes how to reform them to actually improve the incentives of shareholders, managers, and workers alike. Now, it has to be said, these actors' incentives are clearly complex due to heterogeneity within each category, overlap among them, and differing degrees of corporate power to pursue their respective interests. But if we take the standard account on its own terms and focus particularly on risk-taking incentives, we can usefully think of these actors' incentives and degrees of power, broadly speaking, in terms of overlapping spheres. Now, in the paper, I've described this figure. You can tell me if you think this works or not. I've described this figure as a stylized scatter plot that doubles as a Venn diagram if you squint at it from the right distance. Basically, drawing circles where individuals within each group would likely fall by reference to these two axes, while at the same time inviting reflection about how these groups might actually overlap. Now, as a scatter plot, the figure plots individuals within each category in terms of the strength of their risk-taking incentives and their degree of governance powers, acknowledging again that there's heterogeneity across these categories. So in general, shareholders have higher risk-taking incentives and intermediate governance powers. Managers have lower risk-taking incentives and higher governance powers. And workers have lower risk-taking incentives and lower governance powers. Now, as a scatter plot, the overlap illustrates effects of structures that push the incentives of managers and workers closer to those of shareholders. Notably, those legal structures alleviating managerial risk aversion that I noted earlier, as well as the effects of structures like equity-based pay for managers and workers alike. As a Venn diagram, the overlaps illustrate effects of structures that literally blur these categories, notably equity-based pay for managers and workers, and then systems giving workers more direct involvement in management. Now, the core claim of my paper is that structural reforms to mute shareholders' risk incentives could address the drivers of unsustainable corporate conduct more coherently and effectively by aligning incentives of all three sets of corporate actors toward less risk-taking and longer time horizons. Now, this, I think, would seem to offer real advantages over piecemeal reforms that layer on further complexity to an already internally inconsistent framework. So how do we do that? Let's consider how the incentives of each of these sets of actors might be reformed to favor more sustainable operations. If fully limited liability promotes excessive risk-taking and cost externalization, then logically, we ought to consider ratcheting up liability exposure to curb shareholders' enthusiasm for risk and strike a better balance between entrepreneurial investment and sustainable production. I'm not going to dilate on the details here, but it's important to note that shareholder liability is not some kind of on-off switch. There are lots of workable strategies for modestly increasing shareholders' exposure without throwing open the door all the way to partnership-style joint and several liability. Most proposals to this effect build on the assessable stock model and identify various mechanisms to finely calibrate exposure, including based on the corporation's size and or industry. Like, for example, perhaps it's an industry that has peculiar moral hazard concerns like finance. We could focus on the type of actor, the type of liability, various types of caps on liability, whether they be multiples for assessment, asset exemptions, et cetera. Now, although such proposals mainly focus on financial firms, particularly in the wake of the global financial crisis, there's no reason they couldn't be pursued in other industries that involve similar moral hazard dynamics, nominally private industry, but where that industry is relied upon to essentially provide something like a public utility. And note, by the way, that here the substantial intermediation of capital markets is actually a plus, because in reality, at least in the United States, it wouldn't generally be retail shareholders, individual people who held assessable stock. It would be institutions. And that means that the practical regulatory challenge here would actually involve thinking through what prudent capital regulation would look like for various categories of institutions holding that stock. Note also that the trend towards supply chain due diligence laws could itself be viewed as a shareholder liability structure. Literally, to the extent subsidiaries' liabilities are falling on parent corporations, but also practically to the extent that suppliers' liabilities are falling upon lead firms in contractually organized value chains that were probably at least in part organized in that way specifically to avoid corporate law liabilities. Now, other structures favoring shareholders and implicitly their risk incentives could also be reformed to reinforce this shift, including broadening the corporate objective and making new modes of corporate litigation available to non-shareholder constituencies. Noteworthy models along these lines would certainly include Canada's oppression remedy, which was noted earlier. For managers, then, I'll just briefly note the obvious corollaries. To the extent that insulation from liability exposure for care breaches aims to free up managers to take risks that shareholders with fully limited liability want, it's reasonable to question whether that sort of insulation still makes sense if shareholders' own liability protections were reduced to some degree. If managers' own liability exposure were increased to reduce risk taking, then this could be precisely calibrated through structures that resemble those that I noted a moment ago. At the same time, nascent trends toward expanded conceptions of the corporate objective and toward more robust enforcement of the duty of care point toward reforms that could further improve sustainability incentives for managers. For example, the topic of expanded oversight duties came up a couple minutes ago. In addition to this, more broadly pitched duties of care owed by the corporation itself would be possibilities. Market pressures then might be redirected through reforms to financial accounting, essentially broadening the categories of costs that are brought to bear in financial statements to include those borne by society and the environment, essentially forcing those sorts of costs to be internalized. That would be the aim of impact-weighted accounting. At the same time, reforming pay packages to weight sustainability-based components more substantially should also be on the table. Now, again, there's enormous variation across jurisdictions as to how the worker's role is conceptualized, depending on the degree to which workers are themselves shareholders and or have formalized governance powers. Reforms along the lines already mentioned could straightforwardly impact their incentives as well. But regardless, a number of those reforms could still improve workers' incentives indirectly, notably expanded conceptions of the corporate objective, expanded oversight duties, more broadly pitched duties of care owed by the corporation itself, and impact-weighted accounting would, by design, affect what is expected of workers throughout the entire organization. At the same time, just like managers, workers could be rewarded for sustainable operations, or at least not rewarded for the opposite. More dramatically, expansion of corporate litigation mechanisms could give workers further capacity to bring different preferences to bear on governance. Now, just quickly to sum up, to the extent efforts have been made to align incentives across all of these categories of actors, they have mainly aimed to shift managers and workers in the direction of shareholders through legal structures that alleviate managerial risk aversion and through equity-based pay structures for managers and workers alike. Meanwhile, most reforms aimed at improving corporate sustainability, at least in the States, have accomplished little and may have made matters worse by inviting self-congratulation while in fact just sort of reinforcing the status quo. The reforms that I've described here aim to do the opposite, to shift shareholders in the direction of managers and workers by constraining excessive risk and cost externalization at the source. Okay, so with that, I will conclude. Thanks, and looking forward to the discussion.
Yeah, I'm going to put my timer on as well, although that means I do risk being called by my son, who's just started university and is constantly ringing me up for information like, how do you cook spaghetti for the 50th time? So I know we've all probably experienced that. Okay, so my paper is on the growth and degrowth attributes of corporate capitalism. And what I want to look at here, taking broad strokes, looking at ideas rather than looking at law and regulation, is the tendency for corporate capitalism to both underproduce and overproduce, and that this has implications for sustainability, which I think in some way we need to try and factor in. In addressing this, I'm going to be taking issue with certain settled claims about the growth maximization potential of corporations. And also, I hope to try and find some way of accommodating the seemingly contrary views of both the degrowth position and the pro-growth position, all of which, again, has implications for sustainability. Okay, so corporate capitalism. Oh, sorry. That one there. So it's a given belief that corporate capitalism or capitalism under the corporate form is the best way to maximize growth, and that relatedly corporate law is the best system for maximizing growth. And this is held really from the left wing to the right wing. So from the right wing, as I might characterize these superficial, you could take that up with me. They would say, well, yes, it does. That's a good thing. Sustainable issues, well, meh. And then you have someone on the left, like Michael Galanis, who says, yes, it reproduces the growth model, and therefore there is no potential for reforming companies and corporate laws inherent in the organization itself. And there's plenty of well-known statistics about the CO2 and other emissions coming from corporations as a historical matter. Over different periods, this has been seen as a very good thing of corporations and then a very bad thing of corporations. So if we look at the broad historical period between the 1930s and early 60s, we can see some key thinking around the good growth potential of corporations. So for Coase, it reduced transaction costs. It created a hierarchical structure, which was good for maximizing growth because it reduced transaction costs. For Burley, just some statistics showing how more and more manufactured goods were going to be produced by companies. And even Joseph Schumpeter, who you might think otherwise, saw the whole creative destruction model for innovation as being best achieved through the management controlled organization and corporation. You needed that kind of stability produced by the corporation. So far, so good. Then we move into the 60s, where you have different theories that are seeing the growth potential of the corporation to be a negative thing. So just to highlight one, Baroness Wheezy's monopoly capitalism, which is probably known for older members and not so much for younger members, said that it maximizes growth because it frees management from competition, the disciplining effect of the market. So they just grow, and there's nothing to stop them engaging in this. But for all thinkers, the corporation is seen as a way that transcends the market and radically re-engineers the way in which the market operates in order to transcend those inbuilt limits of the market in a way which is growth orientated. So when growth stops being something that is the way forward, the route to social progress, which it started to be in the late 60s, early 70s, when, of course, growth slowed down as well, these kind of notions of the growth orientation of the corporation started to be picked up as something very negative. So growth becomes associated with corporations, and that is seen as a bad thing. This has built over the last few decades, and there has been lots and lots of different perspectives showing sometimes the class orientation or impacts of environmental degradation, or the race implications, the gender implications. All of these are encompassed in this broad literature. But I think we can divide it into two broad categories, which is those concerned with sustainability and those concerned with degrowth. So sustainability, which is kind of what we're all doing here. Much of it would be built around, for example, Rockstrom's planetary boundaries, the idea that there is a degree to which growth can occur, but after that it becomes problematic for the balance of the planet. So you can still operate within those spaces. But for the degrowthers, broadly construed, what you need and the only way you can approach the problem is by engaging in degrowth. And this is a planned restriction of growth. And crucially, there are no technological solutions to this. And I think that's the key difference in our degrowth strategies. So you cannot rely on science to deal with the problems that are created by environmental impacts. And but most notable or most recent, but I think most noticeable is Sato's recent book on degrowth Marxism, where he shows that the technologies that are developed in order to redress environmental damage simply relocates the damage elsewhere. So, you have your electric car, that's great, so that reduces emissions, but as I think was being discussed this morning, this simply relocates the problems to where the elements of the batteries are being made and so on. So it just shifts the problem from the center to the periphery. And there is the additional problem or conflict that exists at the level of human need. So for some, the Anthropocene narratives are all about containing growth without distinguishing what might be considered good growth, because it has good implications for most people on the planet, as opposed to bad growth, which is sort of very narrowly focused. So it doesn't distinguish on the basis of growth, which is good for social class. So the two most well-known thinkers on this, Piketty and Milanovic, Piketty showing that when you have growth, you have reductions in inequality, raises in income and so on, less emphasis on capital. Milanovic, that the development over the last 40 years has raised the global extreme poor to a much more viable middle. So how do we try and resolve these two seemingly quite irreconcilable positions, the pro-growthers and the degrowthers? Is there a way of dealing with this? Well, I think that a Marxist political framework will allow us to see these issues in a different way, which may influence the way in which we model sustainability issues. So first of all, the issue of corporation and capitalism not being growth maximizers per se. The combination is an instant growth maximizer. Well, mainstream economists know that there are cycles, crises, and depressions, although they tend to see those as arising from exogenous interferences with development and seek exogenous mechanisms for enhancing growth, such as helicopter money and all the kind of post-global financial crisis mechanisms that we saw in play to try and stimulate that growth. But for Marxist political economists, they see that as quite different. That the problems of capitalist growth is endogenous to the way in which capitalism produces. That it's not about the expansion of growth per se; it's about the expansion of capital. And we all know that as corporate lawyers, we say it's all about shareholders, it's all about profit. But we need to, I think about a little further what that means. When we're saying that the focus is on profit and shareholders, what are we actually saying? So from a Marxist perspective, you're saying that there's a particular way of producing growth and value under capitalism. First of all, it's about how you produce. It has implications for how you produce, and secondly, it necessarily creates a sort of degrowth and deceleration of growth position with economic cycles. How you produce? Well, you produce by capturing value created by labor. It's all about how do you take that value created by labor, and historically that has been established by removing autonomy from people and from their life. You remove autonomy, you create dependency, and there are great historical moments when we can see this happening. The 18th century Enclosure Acts, and so on. They're all about creating that dependence on wage. And the second way of doing it is to introduce more technologies. So you create dependency, you discipline labor, you have everyone under the same roof, you increase management, these sorts of things, and then you add technology, and that increases the productivity of labor. Now, from a Marxist perspective, these two elements, the way in which production is created, create creates what people like Foster have called the metabolic rift. That is that there becomes a disturbance between man's interaction with nature. It doesn't become something that is natural and reestablishes itself. The first disturbance, he notes, Marx notes, because it's 19th century stuff, the way in which everything becomes centered around cities. So the country produces the food, the enormous amount of food that is needed to feed the cities. That food is transported into the cities, but the waste that would normally return to the soil, and he was rather obsessed with soil degradation. Marxists usually have their thing that they're obsessed with. So for Marx, it was soil. For David Harvey, it's cement. So, we always have our thing that we're obsessed with. So he's obsessed with soil. So the waste from that production doesn't return to the soil; it returns to the rivers or the seas. So you have that immediate rift from that basis. You have a spatial rift, and this is all from Sato's new book, which he categorizes these three elements. And this is the way, and it's partly related to the way in which everything must be commodified. So whilst you have in the countryside, you have water-based power, which is communally run and controlled and is naturally emerging. With the emergence of industrial capitalism, you have a focus on commodified energy like coal and so on. And that commodified energy is privately owned. It creates money, but it also locates and centralizes capital within the cities again. And then finally, you get a temporal rift. That is simply the fact that nature runs at a different pace to production. It takes time to grow a tree, but production requires things to be fast time. And this recalls for me E.P. Thompson's brilliant piece on time, which was one of those great pieces that blew my mind as an undergraduate. And that you get these causes, these metabolic rifts. But as well as this, the system itself becomes poor at doing the very thing which it is designed to do, which is profit maximize. So technology is very capital demanding, and initially it's very profitable, but gradually it becomes equalized across all sectors, and then it simply becomes expensive. So less profit is generated from increasing amounts of capital investment, with the result that you get two things: an increased churn of endless production in order to skim less, but from a larger amount, and entrenched downturn and degrowth. And the corporate form enables a response to the way in which capitalism endogenously works. How does it do that? Very swift glance through history. So from the 16th to 18th century, clearly the charter merchant companies did kickstart capitalism, and they did introduce the amount of wealth and imperial power to kickstart capitalism in England. But the high growth period in England came not under the company form, but came under the partnership form. And it was from the 1780s to 1820s and a little later, but that covers what is known as Engels pause. We have a very high growth period, not under the company form at all. High rates of profit, high rates of growth. From 1844 in the UK, you have company legislation and the Limited Liability Act, the Act enabling the restructure of capital and so on, but none of it is used. The company form is not used under high growth period because it's not there to generate growth. Capitalism does that until it can't do that. When the company form comes in is at the end of the century, when we have a crisis of overproduction, and an economic crisis that goes on for over 20 years and hits the whole of Europe and America, and as well as particularly England. And it's during that time that you want the reduction of production. And the reduction of production is enabled by all these partnerships and little organizations coming together under the corporate umbrella, finally using the legislation that has been there for decades in order to organize business. Why? To initiate a degrowth approach. And today we have different financial engineered solutions to the problem of the enhancement of private capital, such as share repurchasing. The company literally buying back its own capital, reducing the amount that is there to invest and to innovate. So we don't have, as Robert Gordon says in his enormous book, the great innovation moments that we had in the 19th century, steam, electricity. We only have small developments and innovations. And for Hughes, the problem with innovation is that everything is so rapidly commodified and settled through patents, through so on. We stop development and we stop good growth. So finally, how do we bridge the gap between these two narratives, the pro-growth and the anti-growth narrative? And how does our understanding of how the corporation works enable this? Well, the problem with our degrowth narratives is that really it doesn't distinguish good degrowth from bad degrowth. It's all about we've got to stop growing because the planet is at risk, rather than nuancing that. And I'm taking broad strokes here. And the pro-growth narrative doesn't really distinguish good growth from bad growth. It's all good. If it's over 2%, we're happy. And if it's under 2%, we've got to do something very quickly. So none looks at what would be a desirable form of growth. A critique of capitalism and the way in which it operates to generate a particular form of growth, a form of growth which is about enhancing private capital, not growth per se, not the growth which is an issue for sustainability, but a particular kind of growth, is the kind of growth which is operationalized by capitalism and operationalized by the corporation and the management controlled corporation. So management corporations don't transcend the limits of capitalism, but it accommodates maximization of profits through growth, but also through degrowth. Conversely, it will jettison unprofitable products, which may be good for people. It may be good to have something that's produced cheaply and is useful. But if it doesn't create profit, then it is jettisoned. So I conclude and maintain that taking a different view on the way in which we want our corporations to work would enable us both to enhance the kind of growth which would be good, because we do want growth in areas, sustainability issues notwithstanding, but also to reduce growth, which has much more negative implications. Thank you.
Thank you so much to our speakers. And I will take questions, and we are a bit behind schedule. So I would just ask, keep the questions and also the answers concise, please.
Thanks very much for a really interesting panel. My name is David Jablowski. I teach here at York. I have a question for Per. I want to ask about where you left off, to do with the solidification of non-legal rules into positive law. I'm curious, could you talk maybe a little bit about that process? And it sounds like the kind of thing that requires a buy-in from the legal profession, which obviously deals with or brings up certain challenges, but I'm just curious.
Let's do maybe three.
Robert and Porkadale. I had a question relating to the fact that quite a few of you talk about ESG, Carrie talk about global consensus on climate change, but how do you then fit that within the anti-ESG movement in the US, which is quite a powerful movement and could resist some of what you're proposing?
Hello, I'm Jen. I was told to restate my question in this panel, so I'm doing so. So I do angel investment into climate tech startups, but because of certain regulations as a Canadian, I'm not able to make all the angel investments that I want to. And I'm wondering how to change this both for myself and others, because angel investment and finance is critical for the development of climate solutions. There's three key areas that I have issue with. One is I'm not allowed to invest in certain deals that the lead doesn't have a certain amount of skin in the game, a certain percentage of that deal through the investment syndicate, although that syndicate might be coming alongside a much larger investment. I've experienced personal harm through this because I couldn't invest into a major company prior to its IPO. My US counterparts made a great return from it. And if I had, I could have invested that into more climate tech startups and Canadian companies. Secondly, in terms of equity crowdfunding, Canadians aren't allowed to invest in platforms like Republic and many others, starting at increments of $100. Almost anyone in the world can participate, except people in countries including China, Cuba, Congo, Iran, Myanmar, North Korea, Sudan, Syria, Ontario, Canada, British Columbia, Canada, Russia, and Ukraine. I'll just let that sit for a second. Then finally, in the US, to be an accredited investor, now you not only can qualify by having certain financial requirements like $1 million in assets or 200,000 in annual income, but you can now fill out a quiz if you don't meet those requirements, and you can invest in increments as low as $100. In Canada, we can't do that. That being said, my friends who aren't accredited, they can take 1,000, 50,000, however much they want to the casino with no regulation and put that in, but they can't put it into a climate tech startup. So how can we change this so that Canadians can invest into companies? Angel investment has been shown to improve outcomes of firms. I've been emailing the OSC for 3 years about this. Second question, carbon pricing has been shown to have the potential to reduce emissions almost immediately and as one of the most effective means of doing so. How can we get that across the board? Thank you.
So, Per, there's a question for you. Maybe you can answer that briefly first. Then there's Rob's question. I don't know who want to answer that. And then lastly, I hope you have someone on the panel who has the securities law background to answer Jen's question, to not to disappoint her again. I don't know if Carol wants to speak to that. We'll see. So, Per, we'll start with you.
Thank you, David. It's also really nice to see you again. So, I think Janice Sarah said about 20 years ago, at this time when countries were in a race to create corporate governance codes, and then some companies created codes of conduct for how they engage with workers, and there was a large concern of who really was in the driving seat here, and somehow that has never really fully, happily been addressed. So companies are still in the driving seat for much of these soft norms. At the same time, we don't wait anymore. As Janice Sarah suggested at the time, she said, maybe some of these soft norms will harden into proper law. And I think in the last 20 years, things have changed. So 2 illustrations. One is that the law of vigilance in France of 2017 explicitly quotes the UN guiding principles and says that they wouldn't have made their law if it wasn't inspired not only by the UNGP, but also that it should serve as an interpretive standard. And that's one. There's a lot of other evidence in countries when they make supply chain laws now that refer to the UN guiding principles. You might say that's not actually corporate self-regulation. That's a specific form of soft law that has a very big public penumbra. But at the same time, when you look at the norms and the variety of norms that are quoted by courts, for example, in Nefsoon in Canada 2 years ago, and some other courts now that literally work hard to identify a wide spectrum of norms that is not binding, but that indicates for these courts and for the judges on those benches that there is a growing consensus that these norms matter, and that we haven't found political consensus yet, and sometimes it's also difficult to know how to formulate a uniform standard. For example, in ESG, some countries lament the fact that there is no uniform ESG standard, while others say, let's break that down into a pluralism of norms and let that pluralism do its work. And that actually is quite productive.
Shall I tackle the ESG backlash in the US question?
Yes, sure.
Yeah, why not? Okay. So obviously a lot of this is very current. It's difficult to predict how a lot of this is going to play out. I think if we can view this through different lenses. If we view it through the lens of whether it's likely to impact the actual behavior of, say, large index funds with like $10 trillion under management, my guess is that it's not going to have as much impact on what they actually do as it does on what they say. We've all talked about the greenwashing phenomenon over recent years. We've had sort of a green hushing phenomenon in the U.S. recently, with the likes of Larry Fink, for example, backing away from references to ESG and so forth. But my suspicion is that given the assets under management at these big firms and the actual degree of assets in question under, say, for example, the management of state pension funds in the relevant states, that we'll see more of a change in the way that the largest investors speak than we will in the ways in which they actually behave. To say something, I guess, a little bit more broadly pitched about the political environment and the viability of strong form sustainability-oriented reforms, I think as we've seen across the panels today, there are several different types of regulatory strategies that could actually be fit into different types of legal packaging, as it were. So take something like a supply chain due diligence law. Do we imagine that the United States would ever adopt an EU style supply chain due diligence law anytime soon? It may seem laughable to any casual observer of American public life that could happen anytime soon. But I think it's fair to say that it's a lot more likely if it were packaged as trade rather than if it were packaged as corporate governance. It's easier to, for various reasons, it's easier to achieve left-right partisan political consensus on issues like this when they're packaged as a matter of trade than it is when they're packaged as a matter of corporate governance. And so that's something we could unpack over coffee. There's not sufficient time, but in any event, I would note that things like that matter. With respect to proposals of the sort that I'm making, you could view it as very, very radical or relatively more modest. Maybe an observer says, "Oh, this is radical. That crackpot Bruner wants to blow up the very foundations of corporate production." But by the same token, one might say, "Well, maybe this is a little bit more modest if it allows us to hold constant a lot of other structures in corporate governance." To put it differently, maybe shareholder primacy isn't so bad if shareholders have better incentives. So a lot comes down to how these things are packaged.
And I just want to remind my first slide on quick clarifications and how maximizing profit is not the law in Canada. It is best interest of the corporation, whatever the directors determine that to be. And we have to be careful not to shorthand shareholder interests as well to automatically mean profit above all else. I mean, it's just, to me, sort of shortchanging and sort of highlighting the weaknesses in terms of corporate law and what it actually is, because there is then the room in order to just make that interpretation. Just briefly with the comment on the ESG too, I will say, this is why I note that these terms have a shelf life. I feel like it's similar to the term woke, which was kind of co-opted and now seen as an insult. And so what happens is these words get some baggage to them. So you just, and then you move on to a different word that has some other elements to it. And the fact that there's so much pushback in the US, and there isn't here in that same sort of sense, to me is sort of showing how threatening and effective it may be. But surveys have shown that in Canada, 74% of institutional investors have indicated that they care very much about these broader factors and that they're very relevant in terms of their investment decisions. And the other thing is that there is seemingly more teeth in the sense that you can be sued for making a misleading, incomplete sort of disclosure in terms of what you have regarded as material interests and risks and opportunities to your company. Because already under the securities laws, you have to disclose material risk, right? So it's not really breaking new ground in a lot of ways, because again, ESG is a very movable thing. And the example people have said is board diversity. I'll say, since 2015, Ontario's had a comply and explain regime. And we've sort of seen how that's evolved in ways where all we were getting were these random equity statements. And now actually there seems to be some more of an effect. And we've also implemented diversity in the CBCA Act. So I kind of take that as the American distraction and noise from sort of what we're aiming to move on to here. But there is, I think it's because it's seemingly quite effective in being a mainstream thing that you do see that sort of pushback. I feel badly that I can't answer that question so much because I don't know the particular details in terms of the clean tech, et cetera. I will say that, if you were a Chinese company, I would have answers as to why I think there's been some sort of an interference and prevention in doing that. Given CFIUS and also the Investment Canada Act, but I can't go beyond really in understanding that. I will say in terms of carbon pricing, in terms of some of these, cap emissions sort of policies, it's very hard to implement these sort of things when you've got a minority government and a federal election looming. And in a way, we are trying to push for the Liberal government to be kind of aggressive to differentiate themselves from the Conservatives while also planning for some sort of way to phrase particular policies without even saying the word climate, so that it's all just about fiscal responsibility, et cetera. So that's my short, I guess, answer in terms of the limitations right now in implementing like significant policy to address carbon pricing, et cetera, and also some of the challenges that have been held in court to some of these more ambitious types of legislation. We just saw right now the Impact Assessment Act getting, pushback. And so, it goes on, that challenge. And that's why sometimes it can feel quite hopeless, but we move on. So
Do we have a question in the chat online? Yeah. Okay.
The question is from Alyssa, and she says, what are people's thoughts reading if considering ESG is breaking or required for fiduciary duty?
If you have fiduciary duty of care, right? Reasonable, prudent person in comparable circumstances exercising the care, degree, and skill. I'm butchering it, but you understand. And so that in the measurement of ESG, again, it depends very much on that organization, what that constitutes. Particular companies, such a mining company, for example, cannot ignore Indigenous consent potentially and the legislation surrounding that. But that's going to be much different than, let's say, a restaurant chain, as opposed to, there are different factors that one may need to take in. So what you do is you sit down with your board and you think about who are the stakeholders, who are the relevant constituents, and what's kind of our plan going forward. And you design your own in terms of the materiality of that risk. Does that tie into fiduciary duties? Well, to me, yes, your duty is to the best interest of the corporation, and your determination on what that is includes understanding those stakeholders that are involved. And to ignore ESG, again, whatever you want to call it, is a liability risk. It's just to your detriment. And so I can make the business case till I'm blue in the face. I can make the legal case as well. It to me isn't that difficult or controversial. It's something that I think people have been doing for a long time. It's just now it's a disclosure type of issue and a materiality issue that increasingly many stakeholders are aware of.
Right. Could I just say one word? So imagine if you teach in England and the focus is very much on jurisprudence and what courts do. And if one looks at one of the big books that we still read there, it's Ronald Dworkin's Law's Empire. And if one goes through that, then one always wonders of how the judge not only looks back and tries to be in communication with what the judges before the sitting judge have decided, but also to reach outside and to try to make one's own judgment or the court's pronouncement on what they think the law is right now to resonate with the public. And that made Dworkin really famous. If you now look at who produces ESG standards, then it's actually amazing how dense that is, because it's business consultancies, it's investment funds, it's listing exchanges. And of course, for the hard-working scholar, that's a nightmare, because those are not lawmakers, those are not judges, they're not in any way democratically legitimated. At the same time, it's obvious that the market responds to that and also creates those norms. And those norms more and more find their way then into this type of internal solidification that, for example, the Vedanta Court so angrily picked up on. The Vedanta Court was, if you ever read that, you don't only have to read the first few pages, but the court said, I can't take this anymore, that the corporate defendant lawyers keep burying us in documents, because the case that the plaintiffs here make is so obvious. They say that the corporation did roll out a relatively extensive program of how they think the operation of their subsidiaries should work. And that's exactly the standard by which we hold them. Now, is the company a lawmaker? No, but the market and civil society organizations and government, we all create these norms right now, and they become more and more tangible. The Bangladesh Accord is still not obvious what it is. And it has already created several accords now, so that the entire region has garment industry self-regulation that is quasi-public, quasi-private, but nobody actually worries about that so much anymore because it's effective.
But our wages haven't increased though as a result. I mean, we've got safer factories. But we do, when we talk about sustainability and human rights, we do tend to leave it at the door of, pretty radical exploitation, levels of exploitation. It doesn't seem to cover that. I mean, obviously, exploitation covers human rights and the sustainability issues, but it's quite a limited engagement in the betterment of society.
That's so brilliant. But that's why political economy, especially for the current generation, is so important, because we're not talking past each other. I'm not defending market self-regulation, and don't worry that the state has actually not stepped in because it lets that private self-regulation do its course. It's a correlation between both. But the problem is that so many times we discuss that completely separately. The ESG folks will discuss that outside of what Lorraine worries, namely, why don't we have the state re-participate in that? And that's really where the action is.
To address that just quickly by reference to fiduciary duty, which I think is how the question was stated, and on this point of law versus market, even in Delaware, managers have extraordinary discretion to define the time frame for the pursuit of corporate goals, and managers of even moderate creativity could come up with a way to square almost anything they wanted to do with the long-term interests of shareholders. The real question is, what are the other vectors emanating both from corporate law to some degree, but perhaps more pertinently from the market, that affect how they exercise that discretion. And this comes back to the notion of a regime that was noted in the first in the first panel, when we talk about the distinction between corporate law on the one hand and corporate governance on the other. In the latter, we're talking about the full set of both legal and market vectors that affect the ways people actually make decisions. And this is why the question is so much bigger than just how we pitch fiduciary duty.
Okay, great. So thank you so much to the panelists. And I think there's a coffee break right now. Yeah, some discussion over coffee. Thank you so much.
Well, welcome back, everybody. We're ready for our last panel of the day, which is entitled The Best Path Forward for Canada. My name is Hassan Ahmed. I am a law professor at the University of British Columbia at the Allard School of Law. We have 4 great speakers with us today, 1 online and 3 here in person. So it's my job to introduce each one of them. We're going to begin with Sherry Meyerhofer, who is the first ombudsperson at the Office of the Canadian Ombudsperson for Responsible Enterprise, or CORE. She is an experienced lawyer with expertise in the oil and gas industry and in international governance, rule of law, and human rights. After her, we're going to have Emily Dwyer speaking. She is the policy director at the Canadian Network on Corporate Accountability, an NGO specializing in corporate accountability issues. Previously, Emily was the program officer for Latin America for Lawyers Without Borders Canada. Next to her is James Yap. James is a lawyer specializing in business and human rights. He was counsel in the case of Nevson and Araya Resources, as well as counsel in Toussaint in Canada. He is the president of Canadian Lawyers for International Human Rights, or CLAIR. Lastly, we have Professor Sarah Seck. She is the Yogis and Keddy, I hope I said that right, Yogis and Keddy Chair in Human Rights Law and Director of the Marine and Environmental Law Institute at Dalhousie Law School. So we're going to begin with Sherry, who we have online. I've let the speakers know for this panel, I will be cutting you off at the time limit, but I will give you a 1-minute notice to do so because we want to leave sufficient time for questions and answers and discussion at the end. So Sherry, I'll turn it over to you.
Great. Thanks, Hassan. And hello to Sarah, Emily, and James. It's an honor to be joining everybody online. So can we then move to the next slide, please? So I'm going to talk today. Back up. Back up one slide. Yes. Overview. Thank you. That's great. I'm going to talk today about our mandate quickly, about our complaint process, give you a little overview of our current complaints and the investigations that we're working on, from which we have derived a number of lessons learned. And so my last couple of slides will be on what is working based on our experience and what we want to improve. So that's the overview of my presentation. So can we move to the next slide, please? CORE's mandate. So just overall, the CORE is a business and human rights ombudsman institution. We're the first of its kind in the world. We were created in 2019, and our mission is to promote human rights and responsible business conduct by Canadian companies overseas in 3 sectors: garment, mining, and oil and gas. Our mandate has 4 components. They are to promote human rights and responsible business conduct, and that's quite largely, and the underlying documents of those, which have been mentioned by previous speakers, United Nations Guiding Principles on Business and Human Rights, and the OECD Guiding Principles or Guidelines. And then we are to advise Canadian companies, as well as the Minister of International Trade, on best practices related to responsible business conduct. And then the third, we're to review complaints. Review is a very broad category, and I'll take you through that in another slide. And then to make recommendations, and that's on actions and remedy for companies, but also, again, to the Minister of International Trade. And these recommendations can include trade measures. Next slide, please. Just a little bit about our complaint process. It's central to the work that we do. We provide the ability to review and to bring parties together. In order for us to deal with a complaint, it has to be admissible. And the criteria for that are, it must be related to a human rights abuse, internationally recognized human rights abuse, abuse must have happened outside of Canada and involve a Canadian company, and it must be in the 3 sectors that I previously mentioned. And finally, it must have started after May 1, 2019, which is the day we opened the doors of the CORE, or if it started before that date, it's ongoing. And just to be clear, Canadian company, the definition in our mandate is broad. It includes Canadian entities and suppliers, contractors and subcontractors overseas. And I just wanted to mention that I can also initiate an ombudsman-initiated review without the filing of a complaint. Next slide, please. So as promised, I wanted to take you through our complaint process and the review component of my mandate. I'm not going to go into detail of the 5 stages, but this graphic that you see in front of you illustrates the process that a complaint follows as it moves through the CORE's human rights responsibility mechanism. The process, it's important to note, is not linear, and complaints may move from investigation to mediation with agreements of the parties. So the goal of these first 2 stages, which are intake and initial assessment, is to obtain information. It's to review the admissibility and to engage with the complainant and with the respondent company to try to find a solution. And if a solution is not possible at the initial assessment stage, we will address next steps. And that's looking to stage 3, mediation, or stage 4, investigation. With respect to mediation,
If the parties agree, a mediator helps parties to try to reach a settlement of the complaint, and the mediator is a neutral third party. And if court decides to investigate, mediation is not possible. We gather info in two different ways, and that's through joint fact finding or independent fact finding. And then finally, we have our follow-up stage, and that's where CORE reports on our findings, and we make recommendations for remedies and for changes, and we make those recommendations public through publishing them on our website. Next slide, please. So just a quick overview of our current complaints and investigations. As you can see from this graphic, we're currently have 20 complaints before us at various stages of our process. We've laid it out there: intake, initial assessment, investigation, and follow-up. Overall, we have 14 complaints that are related to the garment sector, that's in blue, and we have 6 that are related to the mining sector. Anyone who's been following us will know that over the course of the summer and early fall, we have published 8 initial assessment reports. And all of these reports relate to complaints about allegations of the use of weaker forced labor in Xinjiang. And these are available on our website. In these reports, we have announced the launch of 7 investigations into a number of garment companies and one mining company. And then we also announced one where we're doing we're monitoring it for compliance. So we're making recommendations to a company, and we will follow up to see whether or not they are following our recommendations. So based on that experience that we've had, if you could just move to the next slide, please. I'd like to look now at what is working. So the publication of our first 2 initial assessment reports in July, people are interested in this. You can tell that the public is interested and they want to know what's going on because we generated a lot of media coverage, both in Canada and overseas. So over 100 articles were written and hundreds of thousands of readers were reached. So that's the Globe and Mail, the BBC, the CBC, NBC had a short clip on their broadcast. So although we do not have the powers to compel testimony or documents, the response that we have seen to the publication of our initial assessment reports has shown that our process is important in terms of the leverage we have over companies who are concerned about their reputational risk. So publication we've had some leverage there. If a company opts not to cooperate during our complaints process, and we report on it, and we decide to pursue an investigation, so these investigations become public, and that's where we are with 7 of these files right now. We were in the investigation stage. This investigation, once we're completed it, we will then issue a final report, and we'll make recommendations to the company in that report, and we will follow up to check later on as to whether the company has implemented the recommendations. And we will publish a follow-up report too. So there's a number of points in our process where we will make our findings public. And again, which will impact the company's reputational status. So just to mention again, companies have become more cooperative with our complaints process since the publication of these reports, and it has increased cooperation and is already leading to better outcomes. And we'll continue to report on that. We have good news stories. One complaint was withdrawn by the complainant because the company, with the threat of publication, provided the complainant with information that satisfied them. And so in this case, the name of the company will not be published, and that's an incentive for them. In another case, the company provided information that sufficiently addressed one of the allegations, and this was mentioned in the initial assessment report, which was a good news story for them, even though there was a report published. So aside from the complaint process, we've also had companies and industry associations proactively reaching out to us to learn more about our mandate and how we can support their work. So this type of engagement is very important to the core. So that's what we think is working. So now and this is my last slide, what do we need to improve? So expanded powers to the core. So despite our early successes, there is room for improvement both within the core and the broader Canadian responsible business conduct regulatory ecosystem. While we've experienced some cooperation from companies, concerns remain regarding lack of engagement. In particular, we're concerned with the trend of companies not providing specific information to address complaint allegations Instead, they refer to generic corporate statements or provide responses that are generic in general and don't address the specifics of the complainant's allegations. So in this respect, the Corps continues to reiterate its position that Canada has the capacities to strengthen effective redress for human rights and environmental harms by providing the Corps with the power to compel documents and witnesses. And as I explained in other fora over the last couple of years, giving the Corps the powers to compel would improve access to effective remedy for impacted individuals and communities who do not have access to relevant information and who may face retaliation. It would incentivize Canadian companies to voluntarily participate in the Corps' complaint process, including the use of consensual dispute resolution. And it would demonstrate that Canada is meeting its obligation to ensure that access to remedy is part of corporate accountability for human rights and the environment. We also feel that the Fighting Against Forced Labor and Child Labor in Supply Chains Act is a good start. And I won't give you the details. I know others will speak to this, but the Act imposes obligations on entities producing and selling or distributing goods in Canada. But it's a reporting, and what we're afraid of here is that it's reporting. It's a box checking exercise. It has a narrow focus. It's just on forced labor and child labor. It doesn't cover other human rights abuses. It's narrow in scope. Given its definition of entities, the Act will exclude most SMEs from reporting requirements, and this is relevant for the Corps' mandate because most of Canada's garment companies are SMEs, and there's a lack of requirement to conduct actual human rights and environmental due diligence under that Act, and a lack of focus on prevention and remediation. And then finally, looking at mandatory human rights and environmental due diligence legislation, this is what we think Canada needs. It's the way other countries are going. I know others have mentioned that, and we fully support this. It would cover all human rights. It would require the identification and the prevention and the redress. So this is where the Corps hopes it will go. I just want to sort of mention, we do hope too that our publications and the decisions that we're making and the recommendations we make to companies will also inform courts or tribunals or other sort of entities who are looking at how to hold companies accountable. Thank you.
Thank you, Sherry. So next we have Emily Dwyer.
Hi, good afternoon. I have a PowerPoint somewhere, but I'll start talking and we can get to it in a moment. So my name is Emily Dwyer. I'm the Policy Director at the Canadian Network on Corporate Accountability. I work from Ottawa, the unceded traditional territories of the Algonquin Anishinaabeg peoples, but our membership is based across the country with partners around the world. So thanks so much to all the organizers and the fabulous presenters who preceded me. I've really been enjoying today. The CNCA is a network of 41 member organizations that has been convening civil society organizations who are active on business and human rights since 2005. Our members include human rights, environmental, faith-based research and solidarity groups, as well as major Canadian labor unions. We have representatives across the country. Our members have longstanding relationships with community leaders, women, and Indigenous peoples negatively impacted by business activities around the world. And collectively, our membership represents the voices of millions of Canadians. So our central mandate is to respond to the calls from impacted people around the world for Canada to introduce binding measures to ensure Canadian companies are required to respect human rights, face real consequences for failure to do so, and that negatively affected people have access to mechanisms to both prevent those abuses and to access a remedy in the case of harm. We have had a historical focus on the extractive sector for probably obvious reasons, but the policy proposals we put forward are across the board. we focus on measures to respond to business-related human rights violations outside of Canada, and I wanted to comment on that quickly before I get into this. The focus there is not because there's not violations here in Canada or that because we think that there's adequate mechanisms to prevent and remedy those violations. Quite the contrary, recent UN Special Rapporteur visits to Canada from the Special Rapporteur on the Rights of Indigenous Peoples and on contemporary forms of slavery demonstrate there's lots to be doing here, particularly for Indigenous peoples and foreign temporary workers. But our focus on impacts abroad is partly just because of our historical partnerships, our focus on federal law reform, on addressing the unique barriers that people face when trying to access Canadian courts for impacts that have happened overseas, and because of the constitutional division of power. So I can get into that more. People are really interested in getting into that kind of discussion. And we do our work in a variety of ways. We develop policy proposals, convene meetings, organize grassroots mobilization campaigns, do media work, convene civil society. We luckily have a really active membership and steering committee and lots of allies in the legal community and around the world, which helps because we're a staff of 2.5 full-time people. So why do we do this work? I think it goes without saying that people here likely have a good sense of the fact that there are really significant, widespread, well-documented human rights abuses that that are linked to Canadian businesses and companies and Canadian supply chains in particular. I won't get into those in that much detail. You can look at the Canada brand that the lead author, Shini Mai, is over there, that documents that quite well, and would just say quite quickly that being a human rights defender around the world, working on corporate accountability issues, it's extremely dangerous. And the mining sector is repeatedly the sector where it is the most dangerous for human rights defenders around the world. We do this work. We have a particular focus on Canada, in part because there's a particular responsibility in Canada, in part because of our global share of the extractive sector around the world. It's about 60% that are based here. And the extractive sector has a really significant human rights and environmental impact. Canada has been talking about business and human rights, corporate social responsibility, responsible business conduct for a really long time. There were parliamentary recommendations back in 2005 that were really strong about the kinds of measures that were needed, and yet still now we're quite focused on voluntary measures. So I'm not going to talk about our whole business and human rights agenda, but just to kind of wanted to frame that our view is that there's a lot that needs to be done in Canada in order to respond to the corporate accountability gaps that exist. I'm going to focus on 2 of those issues today, quickly mentioning the core and then talking about our campaign for human rights due diligence legislation. I think that Sherry did a good job in talking about a lot of the problems with her office right now. Our network campaigned for over a decade for an effective office. In 2018, Canada announced that they were going to create an independent office with robust powers to investigate. And then it was gutted as a result of industry pressure before the office holder was mandated. I think just to say the teeth, the power, the only thing that this office has is being able to get at the truth and make public recommendations in its reports. And back in 2009, the Minister of International Trade commissioned expert opinion on how to make the office effective, how to give it these powers. And it said that without the power to compel documents and testimony, its effectiveness would be dependent on the cooperation of companies. So I would say this is not the first of its kind in the world office, because it doesn't have those powers. It's actually more like the national contact points around the world. And it is also not really properly understood as a mandatory mechanism, because really it's still dependent upon the voluntary participation of companies. I would love for the office to have some impact to help impacted people. But since 2005, Canada has been hearing about these harms, talking about doing something. CORE's been in operation since 2019, and there's been zero improvement for anyone who has been killed, raped, or had their homes destroyed. So on to the main focus of our work. Our network has been campaigning for mandatory human rights and environmental due diligence legislation. We published a model law in 2021. It was taken up as a private member's bill in 2022. And we're looking forward to advancements soon, which I'll get into that in a moment. But just to talk briefly about what we are looking for there at a very high level, we've said that Canadian human rights due diligence legislation needs to focus on preventing and remedying harm, needs to help impacted people access remedy, and needs to apply to all human rights. So the model that we put forward includes centered around 3 pillars: establishing a corporate duty to prevent human rights abuse and environmental damage. Second, creating a corporate obligation to undertake adequate human rights due diligence procedures. And third, ensuring that there's access to remedy and enforcement of human rights and environmental due diligence obligations. So this would, in part, the ways in which access to remedy would be ensured is through establishing a right of action in Canadian courts for harm or for failure to do due diligence, because we're centered around kind of the idea of prevention. So meaning that you could have people would have a right of action if harm was caused, and also if a company is acting negligently, but harm hasn't happened yet, if they're not putting in place due diligence mechanisms, that a suit could be brought. Into our model, we incorporated a limited defense where a company could seek to avoid a court order by showing that they had undertaken effective due diligence measures. So one of the pieces to talk about right now also is, in the current context, Canada recently passed a Modern Slavery Reporting Act, S211. Our network's position is that the legislation is at best meaningless and at worst damaging. The reason that we consider it to be meaningless is that it doesn't require companies to stop using or to stop profiting from child or forced labor. It doesn't require companies to take any steps to identify whether forced labor is in their supply chains. It doesn't require company directors to certify that their supply chains are free of forced labor. If companies do make use of child or forced labor, the bill doesn't offer any help to the victims at all. So companies could comply with the law by taking no steps at all, or by taking patently inadequate steps, remaining willfully blind and continuing business as usual. And that's exactly the kind of evidence that we see from other countries with this kind of legislation. So the UK and Australia. So I'd quote from the UK Modern Slavery Reporting Registry 5-year review. It, quote, revealed no significant improvements in companies' policy or practice, end quote. And another quote, it failed to be an effective driver of corporate action to end forced labor. If you'd like more recent quotes, Robert McCorkadale over the last 4 days has made similar remarks about the ineffectiveness of reporting and voluntary mechanisms alone as being a response to changing corporate behavior. So we are really trying to call on, the reason that we think it's damaging is because there have been commitments in Canada to do something more. There are commitments to bring in human rights due diligence legislation, which if I talk quickly enough, we'll get to in a moment. So part of what I have been talking about, or what I wanted to bring to this piece, was a little bit of kind of cautious optimism. Those of us who've been working in this for a long time, I've been with the CNCA since 2012. Many of you have been involved in this for much longer. It can be really defeating, especially for those of us who spend most of our time talking with members of parliament. It can feel like it's starting things all over again every single time, where you have to talk about, is there a problem? If there's a problem, what are the gaps in Canadian law? Does this kind of, anyways, I won't get into that because that could be another hour. But there are reasons to be optimistic. Global momentum. So here's a map of laws that are laws and law proposals that are coming out across Europe. Canada's really responsive to things that are happening in other countries. So it's a lot easier to be trying to convince Canada to be doing something now when it's saying catch up rather than be the first. There are explicit Canadian government commitments in the mandate letters of the Labour Minister, the Minister of International Trade, Public Procurement and Public Safety. There was a commitment to introduce legislation to eliminate forced labor from Canadian supply chains and to ensure that Canadian businesses operating abroad are not contributing to human rights abuses. This was reiterated in Budget 2023 in slightly different words, where the government committed to introducing legislation by the end of 2024 to strengthen Canada's import ban and to eradicate forced labor. And most recently, ESDC and several other government departments held a consultation with civil society, academics, and industry, saying we've been tasked with bringing in proposing legislation really soon. So they're talking about this. What it will turn out to be remains to be seen. And as I mentioned before, there's a private members bill that's in the House of Commons, Bill C-262, which is based on our model. When the Modern Slavery Reporting Bill came up for debate and vote, no one said it was enough, even the proponents of the bill. Two major political parties voted against it, saying that they were worried that a modern slavery reporting law would stop momentum, and said that we needed to do more. And so those are all very helpful signs. And in addition to that, there is growing public pressure around this. Back in April, we brought a petition with 50,000 signatures. There was a large increase right after we'd already printed out those signs, 43,000, but 50,000 signatures asking the government to move swiftly to introduce legislation. Our model law has been endorsed by 150 organizations and unions from around the world, from 32 countries, organizations and unions that work with directly impacted people. UN visits of various special rapporteurs in the last few years have been unequivocal that a reporting law does not help Canada fulfill its international human rights obligations. And hopefully that will shift things, and as well as letters endorsed by many academics and lawyers calling for this kind of legislation. And I think maybe in the question and answer period, I can talk about some of the reasons why I'm feeling a little bit less optimistic about this current moment, where there are real concerns about corporate capture, that despite commitments to create a quote unquote due diligence law, will that be anything more than a checkbox exercise? Is it going to be watered down from what we need? And again, that human rights and environmental due diligence legislation is but one of the needed shifts that we have. So sorry for going slightly over time. Thank you.
Okay, thank you very much, Emily. Next, we have James Yap.
Okay, great.
Okay. Hi everyone. I'm going to talk to you today now about the situation in Canada with respect to civil liability for corporate human rights abuses abroad in Canadian courts. And to do that, I'm going to talk to you from the perspective of the Nevsun case, which is the background that I'm coming from, basically. The Nevsun case is one that I think most people in this room know. Some of you were with me on that journey over many years. Some of you don't know it. So I'm just going to run over it briefly. Starting first with a little bit of background about Eritrea. This is a country, if you don't know much about, you need to know about, because I think it's frankly outrageous that there's not more talk about what's going on in this country. So it's just really one of the most repressive governments in the world. It doesn't have elections, no legal opposition politically, no private press, no legislature, no constitution. But the most terrible and frankly just bizarre aspects about it is it's got the system of universal forced labor. And incredible as it seems, that's what it is. It's universal forced labor. It's got this program known as the National Service Program, euphemistically. And basically all young people, once they reach the age of 18, are conscripted into this program. They go through 6 months of military training, and then they're assigned to a job anywhere in the country, or they may be sent to additional training to be an engineer, doctor, lawyer, whatever. And then they're assigned to a job somewhere in the country. They have no choice in that. They can't leave. If they try to leave, they're punished severely, detained, tortured, etc. So it's a really terrible and bizarre kind of system. Into this country, about 15 years ago, walks a Canadian mining company called Nevsun Resources, now was headquartered in British Columbia. And in order to build, it reached an agreement with the government to build and operate a gold mine called the Bisha mine in Eritrea. In order to build the mine, it contracted with a construction company called the Sagan Construction Company, which was effectively a state-owned construction company. And that company being state-owned and Eritrea being the country that it is, of course, very predictably, the Sagan company used forced labor to build the mine, so that the Bisha gold mine, and therefore all the gold that the mine produced, was produced using forced labor. Won't go through the story of how the case developed, but effectively, we found plaintiffs and launched a lawsuit in November 2014 in British Columbia, alleging conventional common law torts such as negligence, assault, battery, etc. One of the more unique aspects of the case, though, is that we also decided to incorporate customary international law torts, these being alleging civil liability for violations of the customary international law rules against slavery, torture, forced labor, and crimes against humanity. This is from a rule of the common law known as the doctrine of adoption. The rule being that rules of customary international law are automatically adopted into the common law. And so the reasoning was to take that a step further and say, well, if rules of customary international law are part of the common law, then violations of those rules must also give rise to civil liability. I just want to acknowledge there that I got the idea actually from when I was in law school here and seeing something similar that a really great human rights lawyer in Ottawa named Paul Champ did in a case called Abdul Razik. So that's where I got the idea from. So then the defendant filed various motions to dismiss, which were rejected by the Supreme Court of Canada in January 2020. The motions to dismiss were one on the doctrine of formal Coenian, saying that the courts of Eritrea were a more appropriate place for trial of this issue. We were fairly we were able to dispatch that argument relatively easily by showing evidence from former judges that the courts of Eritrea were in fact not independent. They filed a motion to dismiss based on the Act of State doctrine, which is a doctrine of US and UK common law, which basically states that domestic courts should not rule on the sovereign acts of a foreign sovereign state committed within its own territory. And of course, this national service program is a state program, and therefore the defendant argued that this Act of State doctrine, which hadn't ever been acknowledged in Canada, but should be acknowledged in Canada and concurrently applied to the situation. The court dismissed that as well. And also notably, the defendant challenged our customary international law tort theory and said that, raised a couple of arguments. First of all, that violations of rules of customary international law do not, in and of themselves, give rise to civil liability under the common law. And second, that corporations cannot be held or are not liable for violations of international law in the first place because they are not subjects of international law. And the Supreme Court rejected both arguments in its decision in January 2020. And then, so after the Supreme Court rejected all the motions to dismiss, the case then settled later that summer. But the decision by the Supreme Court is considered a bit of a breakthrough decision globally. So from there, I just want to sort of like summarize what would be the current state of affairs in terms of civil liability for corporate human rights violations in Canada. For non-Canadians, it's still very much a question mark because it's, yes, we wanted the Nefson case, but it does not set much of a precedent to say that the courts of Canada are more appropriate than the courts of Eritrea. And that's a case where it's clearly evident that the courts of Eritrea are not an alternative. And I want to point out, for those who haven't seen the decision last week by the English High Court in the UK, they dismissed a case against Dyson alleging forced labor against a British company in Malaysia, and they said that Malaysian courts were more appropriate. So in countries that have more advanced or better rule of law institutions than Eritrea, where they're abysmal, that still remains a question whether the Canadian courts will accept jurisdiction over them. And also because the Nefson case settled at the point where basically we filed in 2014. In 2020, they told that in January 2020, we got to the point where the court said, okay, you can go to trial. And the case settled then. So we did not go and settle any further actual substantive legal issues. The questions remain around the liability of a parent corporation for the acts of its subsidiary overseas. Now, in that respect, I want to point out that if Canadian courts pick up the customary international law tort claim that was advanced in Nefson, then those claims might help to provide some support for that argument. Basically because some of the reasoning behind bringing those claims in Nefson was that under Canadian law, there's a very, very underdeveloped body of precedent with respect to when Canadian parent companies can be held liable for the act of the subsidiaries. Okay. However, in international law, particularly national criminal law, there's a very developed and sophisticated body of jurisprudence in respect of what's called command responsibility, international criminal law, where they have a whole body of law where that's designed to trace liability from the boots on the ground, like literally pulling the trigger, up a military hierarchy to the very top, because these are the people. These international tribunals, they focus on prosecuting the most high-ranking public figures, right? So they have a very highly sophisticated body of law to trace accountability up a chain of command. In the military context, and we, I guess, transposing that the corporate context. A military chain of command has a lot of strong parallels to a corporate chain of command in our reasoning. And so in our pleadings, as I've put there, we pleaded a lot of the we drew on a lot of the standards in the Rome Statute, Article 28B on command responsibility to try and take advantage of those. And then just to quickly tie that up, sort of like the latest work I'm doing to extend the theories that were developed in NevSun with respect to customary international law involves the application of treaty law domestically, because under a dualist common law system, customary international law is part of the common law. Treaty law is not part of the law unless it's expressly incorporated by legislation. However, there is a rule of customary international law, Pacta sunt servanda, that says treaties are binding. And of course, customary international law is part of the common law. So if you put that together, well, doesn't that mean that there's a common law rule that treaties are binding that you could apply to the federal executive, not the federal legislature, not the provincial executive, but at least the federal executive, who are the ones who entered into that promise, just like they enter into a promise in a standard contract. Contract doesn't become part of the law, but it doesn't mean it's not binding anyway. So that's the latest argument trying to advance in a case called Toussaint, to argue that international human rights treaties are binding on the federal executive. Briefly, it involves a migrant worker who came to Canada, was denied health care for a life-threatening illness, a kidney disease. She filed a constitutional claim. She lost. She filed a complaint with the Human Rights Committee, who agreed with her and said there had been a violation of her rights to life and right to non-discrimination under international human rights law under the ICCPR. And so we brought that back to Canadian courts, trying to argue that the federal executive is bound by the promises it made under international human rights law in the ICPR through customary international law. So we'll see how that goes. The government filed a motion to strike. We defeated the motion to strike, and so it's the case is now proceeding. Okay. So these are the legal barriers. In my mind, though, the legal barriers are the ones that are talked most about. In my mind, the most significant barriers are the logistical barriers. And please forgive the crudeness of this graphic, but just to illustrate, Canada, as you may know, is home to 60% of the world's mining companies, but we're a small country, right? So you've got 8,000 mines around the world, over 1,500 Canadian mining companies. And how does the information get here? And there's really only a handful of Canadian journalists and NGOs that do that. And the analogy I like to use is with residential schools. If you think about all the awful things that happened in Canada in residential schools, how long it took those cases to come to court, and the fact that till this day, we're still uncovering things that happened where, you still find like bodies being dug up that weren't discovered before, right? And this is in Canada. Imagine how much harder it is to find out what's going on in some minor remote location, half a world away, where there may not be any internet or grid or electricity or anything like that. So that's a very, very significant barrier that I want to draw attention to. And then, okay, yeah, great. Okay. And then the other thing I want to throw out is, after all that work in the NevSun case, all those years to try and get that decision, traveling all over the world and interviewing plaintiffs and getting their evidence and fighting in court and all of that. What's happened? Well, first of all, NevSun, the company, no longer exists. It was sold to a Chinese company, and then it's sold. So that interest in the Bisha mine was transferred to a Chinese company. That Chinese company is still operating the mine in Eritrea. Not only that, not long after the NevSun decision, I came across this news one day, which is that there was another mining company, this one also at least listed in Canada, that was also had started to explore potential mining opportunity in Eritrea. And this was after the NevSun decision, after the Supreme Court said, oh, you might be liable for all these customary international law violations. Did that have an effect? Or how much an effect did it have? I don't know. But it was not enough to deter this company from continuing and forging ahead with exploring in Eritrea. And then on top of that, and this links into what Emily was saying about the effectiveness of reporting obligations. In the US, there is a legislation that requires publicly listed companies to disclose where they source certain minerals, including gold, right? And year after year, you can look up on, what's it, Edgar? What's the site in the US? And you can dig up all the reports of these companies, see where they're sourcing gold. And actually, like, if you go through, quite a number of them are sourcing gold from Eritrea, including the ones whose logos you see up here: Tesla, Apple, Ford, etc. I told you about Eritrea before. That's universal forced labor, right? This is a country you can't get any kind of product, gold or anything else. That's not. It's guaranteed, made using forced labor, right? All these companies do year after year since, was it 2014, 2015 when that law was introduced? They just say, yeah, we're getting some gold from Eritrea, and then that's it. So that's a concrete illustration of how effective reporting obligations are. I'm done. Thanks.
Hey, thank you, James. Our last speaker on the panel is Professor Sarah Sachs. So turn it to you, Sarah.
Thanks very much for the invitation to be part of this workshop. And as you can see, I have lots of slides with pictures on them to keep you entertained for the last bit here. This is in part a reflection for myself. I did my PhD here at Osgood. The topic was, does Canada have obligations under international human rights and environmental law to regulate mining companies operating internationally? My starting point today is to say, how might I have approached this question differently had the education that I had received embedded a focus on the rights of Indigenous communities in the Canadian context to the extent that education is moving to do today. And so that's one piece of what I'm going to talk about. And you can see that I've put up Dalhousie University's land acknowledgement, which says Dalhousie is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. We are all treaty people, which places obligations on us as academics to contemplate what that means. The other piece of what I'm going to do today is to draw upon the concept of triple planetary crisis, which is put forward by the United Nations Environment Program. So we've heard a lot of reference to climate change today, but climate change from the triple planetary crisis perspective should be understood as an intertwined crisis with nature loss and pollution and waste. And so that has implications for how we think about climate solutions and some other things that I will speak to. So first, if we take seriously the land acknowledgement that I put on the previous page, we know that international law as a state-centric system is fundamentally flawed, unfair, and unjust. This is because the civilizing mission of international law erased the nation-to-nation treaty relationships in settler colonial states like Canada. So the peace and friendship treaties, which should underlie everything in Nova Scotia, where I'm from, and where I'm currently based at least, are not in the UN treaty database, right? So that should matter to us. And when we're thinking of international law and what are legitimate sources and legitimate arguments, we need to ask whose treaties, whose custom, whose laws, whose judicial decisions, which publicists, and so on. And you'll see in a few minutes where I'm going with that. Now, on the triple planetary crisis point, I've noted the intertwined nature of climate, nature, and pollution. as being an important framework. And of course, there's the 9 planetary boundaries framework, and I actually kind of wish I'd put a slide on that in here, but I didn't. We can come back to that perhaps. If we just take this simplistic version of it, what we know is very clearly the triple planetary crisis has a profound impact on human rights, and different people are more profoundly affected by this. Different people can more clearly protect themselves from the implications and are also more implicated in causing the problem. And we know that in part because the starting point of the problem really is unsustainable production and consumption patterns. And that is of the affluent. So going back to truth and reconciliation, for those who don't know, this is sort of the quick overview of the process. When I went to law school, 1996 to 99, we had a one class of combined property and constitutional law that was not to be examined, where we talked about Section 35 of the Constitution, which recognizes and affirms the existing rights of the Aboriginal peoples of Canada. We had a few little references to it at some other times, but it really was not a core part of the curriculum. Fast forward to 2007, the United Nations adopts the Declaration on the Rights of Indigenous People. Canada votes against it. In 2010 says, well, maybe. In 2015, the Truth and Reconciliation Report comes out following the class action and other litigation in relation to residential schools. There are 94 calls to action, including calls to action for law schools and the law society to center the rights of Indigenous communities, to learn about UNDRIP, to learn about the history, and to learn about Indigenous laws. There's also the Murdered and Missing Indigenous Women and Girls inquiry with calls to justice, including in relation to extractive industries. And then we have an act and so on. So one other thing of interest is that the TRC has a specific recommendation for the corporate sector in 92. We call upon the corporate sector in Canada to adopt the UN Declaration on the Rights of Indigenous People as a reconciliation framework and to apply its principles, norms, and standards to corporate policy and core operational activities involving Indigenous peoples, their lands, and resources. And the Government of Canada, I note, has said quite explicitly on its website that the corporate sector in Canada is responsible for the response to the call to action 92. From the UN Guiding Principles, we have the idea that businesses, of course, are also duty bearers. And so I note with interest this from the website of the Hudson's Bay Company, which, of course, going back to our thinking about corporations and states in history and the roles of them in the colonial practice, I think there's some very interesting, actually, text on this, in which the Hudson's Bay Company is at least acknowledging that there's a problem with the celebration of the history of fur trade and so on, as, the explorers to be celebrated, and acknowledges the role of the people within the company and the company itself in the colonial past. That doesn't mean it's, paying up, reparations or anything like that, but it's actually quite an interesting read. Okay. So let's take seriously the UN Declaration. There's lots in it. I'm going to skip over this slide, but I will note that one of the things that's in it and that is supported by the Canadian government is the idea of revitalizing and a resurgence of Indigenous laws. And so I have a couple of books noted on the side. The Right Relationship, which is about implementation of historic treaties, Resurgence and Reconciliation, which is focusing in part on resurgence of Indigenous ecological laws. And I note a book that I co-edited, which has a great chapter in it by Deborah McGregor, providing a framework for Indigenous environmental justice and how to think about that. But the real slide that I want to get to is this one. So back to Nova Scotia and the Peace and Friendship Treaties. This article is about transforming biodiversity conservation in Canada through re-indigenization principles. It's authored by a group, including Elder Albert Marshall, who's well known in the Mi'kmaq community and beyond. my colleague Sherry Pictou. But what's interesting here also is to note who the lead author is, Misnukmak, which is the name for the traditional territory of the Mi'kmaq, and means all my relations. And we've chosen Misnukmak as lead author to honor the collective and to acknowledge that all stories, learnings, and language come from the land. We are just the conduit. And so they trace through a number of different principles, one of which I note is Nadukalump, which is listed there. And this has been defined as adequate standards of community nutrition and economic well-being that does not jeopardize the integrity, diversity, or productivity of the environment. And that idea is somewhat in keeping with recognition that we've seen by the Supreme Court that the Mi'kmaq have a right to a moderate livelihood fishery. So I stress the idea, if they have a right to a moderate livelihood fishery, how are livelihoods usually understood? Does that mean that others are entitled to immoderate livelihoods? What's going on here? So I'll leave that hanging for a moment and proceed with my second point. Here I'm drawing on some work that I did for the United Nations Environment Program, where I was asked to work in collaboration with partners in including through Sea Circular, which is a body that was created by the coordinating body of the Seas of East Asia, to develop trainings on a human rights-based approach to the plastic pollution and the plastic value chain, with the idea of delivering trainings for states and businesses in the region, but in collaboration with partners in the region, including the Indonesian Business Council for Sustainable Development. So what we ended up doing was choosing to use the right to a clean, healthy, and sustainable environment as a framework in which to deliver the trainings. And I'll note, first of all, nobody said anything about plastics yet. Plastics, we need to understand 99% of them are, 99% of plastics are virgin fossil fuel based derived. The problem of the linear take, make, waste plastic value chain and plastic life cycle is one that has human rights implications at each stage, from the extraction of fossil fuels through transport, issues in terms of chemical additives when it comes to thinking about consumption, huge issues in the waste management and disposal stage, including incineration. And in places like Canada, we pretend that when we buy clothes that have plastics in them, it's fine if we then just wear them for a brief amount of time and pass them along, because that's not going to be a problem. Likewise, we stick our things in recycling and all is good. It's not, and we need to grapple with that. In any case, key point here is that Canada tends to approach its human rights project with the idea that Canada is a leader in the human rights world. And when it comes to the rights for a clean, healthy, and sustainable environment, it's not. It's a huge laggard. And so there needs to be a certain, I think, humbling of approaching when Canada is saying it's going to take a role to talk about human rights to other countries, because there's a huge gap in this area. I could spend easily 20 minutes on this slide, and I won't. I'm probably already running short. But in a quick scan, I will say that it's best understood as comprised of three component parts: the substantive part, including discrete rights to a safe climate, clean air, clean water, and so on, non-toxic places. The procedural rights component being very multifaceted. And I note that increasing numbers of countries are parties to treaties that protect procedural environmental rights, and Canada is not one of them. And then there's cross-cutting attention to equity and vulnerabilities often being created through human rights violations and so on. But I note, of course, there is a UN General Assembly resolution recognizing this right. Canada did vote in favor. This was in July 2022. So let's see what happens. From in our trainings, and how many how much time do I have? 2 minutes. Okay. So in our trainings, we developed all kinds of pretty visuals. But what we were trying to do in particular was to shift from a conversation that just focused on human rights to a conversation that integrated human rights and circularity. And I'll come back to that in a minute, but these are different visuals. One is relating to product design, one to waste management, and one is more clearly focused on the responsibility for remedy and how to think about that. We did also extensively rely on the earlier version of the OECD guidelines for multinational corporations, and their latest version now, I note, in 2023 is even more promising. The OECD guidelines have not received much, if any, attention today, and I think that's very unfortunate. They adopt a risk-based due diligence approach aligned with the UN guiding principles. There is a human rights chapter, but the key thing is that the focus through the due diligence work is on the risk to the rights holders, which is quite different from what we're seeing in other contexts. Every country is supposed to have a national contact point. Canada has one. It has received lots of criticism. This is, if Robert were still here, this is a slide. He used a different version of this slide. Its idea of how to think about risk-based due diligence is quite helpful. This, though, is my important slide in a sense. And I know I have only one more slide and possibly less than 1 minute, but I'll try and wrap this up quickly. Key point here is this. People talk about human rights and environmental due diligence, but the problem is very multifaceted. And what's really interesting about the OECD guidelines is that they provide a tool for taking ideas that come from, for example, the right to a clean, healthy, and sustainable environment, and in particular, the procedural dimensions of it, and show how you can make those real through different chapters. How can you use disclosure in support of the right to a clean, healthy, and sustainable environment? How does that relate to the rights of workers, whether formal or informal? How can you encourage businesses and workers to understand their role in the environmental context? Environment obviously has lots, including lots to work with, but also the problems of bribery and corruption, which if we think about the waste management, transboundary waste management issues is a big one. Consumer interest, sorry, I skipped on that, but the consumer interest ones is huge. There's stuff in there about how businesses should talk to their customers and provide customers with information, consumers with information to perhaps change their footprints. And so here are my next steps for Canada. First, human rights due diligence and environmental legislation is nice, but Canadians have per capita the highest footprints when it comes to greenhouse gas emissions, or at the top, very near the top, greenhouse gas emissions and plastics. We need to talk about the overconsumption of the affluent problem and figure out how to address it. It used to be we talked about reduce, reuse, recycle. The first one now is refuse. And repair comes in there too. The second thing is, I think the OECD NCP possibility in Canada is a huge missed opportunity. I would get rid of the core, focus on reforming and having a really rich OECD NCP, working in collaboration with Indigenous peoples, territories, provinces, so we can have a multi-level governance approach, similar to what we're trying to do in impact assessment law, with ideas of cooperation and substitution sort of embedded in there. And I have other reflections I could make on other pieces, but I will stop there for now. Thanks.
Okay, thank you to all the speakers, and we'll do the same thing we've been doing all day. We can collect 2 or 3 questions. So if you have a question, please go up to one of the mics. We'll collect them and get the speakers to respond.
There we go. Thank you for that. It was very interesting, very informative. As I was sitting there, I was thinking of this question of carrots and sticks and whether those even exist in Canada at this point. So I don't know if this is a longer conversation for another conference, but if you're looking at the landscape today, is there any carrots or are there any incentives right now for corporations to improve their behavior? Say with some of this upcoming legislation, or even in theory with CORE somehow expanding some of its ability to do its work. So incentivizing, carrot, and then stick, and maybe this is a question for James in particular, looking at NEVSUN and looking at some of the other very, very limited amount of law in Canada on this, is there actually any sort of stick? Is there anything you can hold up against some of these companies and say, you know, you're really going to get into trouble and you're going to be in front of a court which will not look kindly upon you for some of this behavior? Thanks.
Any other questions, either online or in person?
Hi, Sherry, this question is more so for you. Like while like there are like reports and news articles on findings that CORE finds, it's not, even though they're out there, not exactly widely advertised in the sense that they're constantly being talked about. So do you find that there is a lot of corporate pushback or trying to silencing of like the media, or I guess, like, what do you think are the reasons that these reports aren't widely spread the way that maybe other news headlines are? Because it's pretty big news.
Okay, thank you. We have a third question. Go ahead.
Question to all the panelists. Do you think wider market education around the distinction between ESG and mandatory human rights due diligence could help drive public interest in supporting this kind of legislation? Because I think as it stands right now, there's so much confusion in the marketplace. People, for example, investing in ESG products may believe that they're putting their money into initiatives that are making a difference. But really, ESG is about financial materiality, not considering the outward impacts on people and planet. And so I think there is a huge gap there and an opportunity to motivate or accelerate progress. I don't know. Federal government has committed to mandatory human rights due diligence, as you noted, but I won't hold my breath for that to come out. Thanks.
Okay, thank you. Why don't we do this? Why don't we go in reverse order of how the panelists spoke? So, Sarah, if you wanted to start, and I can go down the panel from there.
Sure. I mean, I didn't get a chance, I guess, to say that why do I think in part that the OECD NCP thing is so important? But I think in part you see in countries that do have due diligence, human rights and environmental due diligence laws, and also countries which are taking steps to recognize the guiding principles in business and human rights, and also the OECD guidelines in legal actions, are ones that already have, in many cases, independent and if effective to the extent that they can be, OECD NCPs, where conversations can happen about how do we understand what responsible business conduct is in a multifaceted way. So I think we're not really going to get there unless we do that. And the other thing about the OECD NCP, which is hugely important, is complaints can be brought to them about issues that are occurring within Canada just as much as outside. And I think it's a huge mistake to limit the conversation to outside of Canada and to treat it as if it's separate. So if human rights due diligence legislation comes in and it's just outside Canada, I think that will be a huge mistake.
Yeah, I can't really speak to that question as much, but I will speak to Jeremy's question that you directed, re-sticks. And yeah, frankly, I think people need to start going to prison for things, or at least know that the threat of prison is there, even if the charge is brought, even if it doesn't work. I mean, why went over the facts in the NEVSUN case? Crimes against humanity, right? That phrase tells you something. And if a company is faced with a choice of, maybe paying a few $1 million in a lawsuit and going ahead with a multi-billion-dollar generating mining operation, I know what choice they'll make every time. But if there's even the remotest threat of some kind of jail time hanging over their head, I think that's something that will, and look, not to say that civil liability is ineffective entirely either, right? I think it's all part of a big picture, right? The solution is multifaceted, right? But there's a lot more that needs to be done. And I think the possibility of criminal prosecutions, and this, by the way, applies to all kinds of corporate misconduct in Canada, securities fraud, money laundering, corruption, etc. I think we need to step up the frequency of and the threat of criminal prosecutions for all kinds of corporate criminal misconduct in Canada. Emily?
Thanks for the questions. So I think I may comment on both the carrots and sticks one and the kind of ESG HREDD piece. And also I'm going to talk a little bit about the NCP. But in terms of carrots and sticks, I think that if you look at Canada's corporate social responsibility strategy, now it's responsible business conduct strategy, part of what is set out in there are things that are kind of supposed to be carrots around lots of guidance to companies about how to manage risks. That's essentially a lot of what kind of both the core and the NCP have a mandate to produce guidelines, provide supports, provide information. In the latest RBC strategy, there is some talk about the Canadian government talking about leading companies and kind of profiling them around best practices, which we are deeply concerned about when that's happening in the absence of effective oversight and regulation, because it's very difficult to kind of. Anyways, I don't need to get into that in a lot of detail. The responsible business conduct strategy also highlights and promotes the Mining Association of Canada's Towards Sustainable Mining initiative, which is, I think, also a really concerning situation where you have the government of Canada endorsing a private, independent self-regulatory standard that doesn't really work as a kind of a replacement there. So one of the things that we often say is that kind of, I think that there's a bit of a carrot that comes from the stick, that if you have effective responses, then there's benefits for companies in that too. Canada's been saying since 2009 that we expect companies to respect local laws, to respect human rights around the world, and that we believe in that. But it's not credible to anyone around the world because of the fact that there's no way to hold. There's companies who are facing really serious allegations who say that they're great. Barrick Gold is a member of the Mining Association of Canada, and there's a lawsuit against them right now, both in Canada and in the US and other, or not the US, the UK and other places. So I think that for in my view, carrots only really work if they're also attached to sticks, but there are some proposals there are some policies in Canadian legislation. In terms of ESG and human rights and environmental due diligence, I agree with you that there's a lot of challenges around kind of, because we've been having this conversation in Canada for so long, industry associations and companies are quite sophisticated in how they talk about these pieces. And there is a lot, like, there is a tendency to kind of look at voluntary
pieces as being alternatives to effective regulation. And I think on the national contact point, personally, I would distinguish between the OECD guidelines and Canada's national contact point. I think that we see a lot of value in the OECD guidelines and enforcing that. I think the national contact point in Canada is so far gone that it is very challenging to consider using it. There's quite a bit of examples for kind of our members working with partners around the world who have experienced harm because of bringing a complaint to the NCP. So that's part of why it's kind of a piece that we don't even want to go there. To be fair, we also aren't. I would say I don't think it's reform. I think it would be a complete overhaul and kind of starting from scratch. So that I wouldn't say, like, I think that there might be some people who could do that. Our network has just said we don't have the energy or hope to do it. Like right now, it's housed within the Trade Commissioner Service. But I don't want to talk for too long because I also know that there's questions for Sherry, and I'm not sure how long she gets to stay here for.
Sherry, did you want to go ahead?
Sure. Thanks, everyone. I just want to start by saying, Sarah, with respect to whether human rights and environmental due diligence should apply both inside and outside of Canada, I agree with you. It should be both. With respect to carrots and sticks, I agree with Emily that, they can be together. And one of the things that we do know about other, arm's length bodies around the world is that when they're given the powers to compel documents and testimony, they either have rarely or never used it. The fact that they could do it is enough of an incentive for a company to engage if they can see that it's pending. So I think you can put those two together. I also think that, like as I said in my presentation, we need legislation that applies both inside and outside of Canada. And I think the organization that is set up to hold companies accountable to that should also be under legislation. So that, that's, whether it's, an NCP type body, which is, I would just mention, as Emily said, it's embedded within the department. It's not even arm's length. So whatever body is going to do that needs to be under legislation. And I agree, it should have expanded powers. It should have, it probably cover all sectors inside and outside of Canada. And so all of those things are good, and they would provide sticks. And then when you have a stick and you have that ability to influence, that they also would act as carrots. So I would just sort of say that. And that's on the first one. With respect to the question about why aren't the reports being more widely spread, I'm not sure that that's a true statement. I actually don't know. I do know it hasn't got the same media, although every time we do another report, because they've done a number of iterations of reports as they become due when they're ready to be published. We have continued to get media attention. So it's not just July. Every time we've published it, we've been on the front page, across the country. And so it's there. I also know that our decisions are being read by people in Geneva. We've heard that back. We've read your decisions. We're watching what's happening. So I think there's a lot of quiet following of what we're doing, a lot of interest in what those investigations are going to show, what our recommendations are going to be, and how impactful the follow-up will be, the reaction to those in the follow-up. So there's some stuff to do, but I'm not sure whether that's a true statement or not. I hope not. I hope it's more widely spread than, the media jumps from one story to the other all the time. So I'm not quite sure, but I do know that people are reading them.
We still have a few more minutes. Does anybody else have a question? Go ahead.
Hi, thank you for the great talk. My name is Ryan, and my question was, when we think about, almost like planetary rights and human rights, often it feels like companies, instead of planetary and human, it's almost planetary or human. When James was talking, all those companies, they, for instance, Apple or Tesla, Apple said, oh, we just came out with our carbon neutral watch, aka, we're really helping the planet. But then at the end of the day, where they extract all their minerals and everything, there's so many violations of human rights. And same with like Tesla, oh, we're saving the planet because we have electric vehicles. But then where does that all come from? So I was wondering if you could maybe touch on this, this idea of like human and planetary and how companies, kind of look at both those aspects. whether together or separately, or what you would suggest.
Thank you. Anybody else? We have one more question. Let me just add a third question. You can come up still. I'll ask my question, and then you can add your third one. What I've kind of gleaned and noticed, and knowing all of you previously in the work that you do, I kind of see a spectrum between, on the one end, you have these soft law investigatory mechanisms, and then somewhere in the middle, you might have the potential for mandatory human rights due diligence. And on the other end, you have these hard doctrinal laws, civil liability, even potentially criminal liability. What I'd want to know from one or more of you is, how does the work of the other people on this panel feed into your work? So how does the Corps' work feed into whether it's human rights due diligence efforts, or whether it's civil litigation efforts, whether it's international law efforts? How does your work complement one or more of the other people on the panel? And we have a third question.
Thank you. So one of the concerns that are raised with regards to ESG ratings and the sustainability ratings are the issue of credibility and completeness when it comes to vouching for data that comes within the value chain. So it's a great initiative for Canada under its responsible business conduct strategy. Now, how do you guarantee the credibility of information that comes down the value chain? If, for example, a Canadian company is operating in somewhere in Africa somewhere, where the system with regards to sustainability is not so robust. So maybe the government is so lax when it comes to anti-corruption. The transparency is very minimal. You may be having the same issues of greenwashing as others in some other context style it as blue washing. You may be having that, but on your books, it's looking good. So to what extent is this strategy going to be so robust for investors here, and even for parties in other jurisdictions to be confident that these strategies are actually going to deliver the results they intend to? Thank you.
Okay, thank you very much. I'm cognizant of the time. We just have a few minutes, as I understand. So if anybody wants to, I won't necessarily go in any order, but if anybody wants to speak up about any of those questions, yes, sir, go ahead.
Thanks. Just to know, first off, in Western thought, right, the nature-culture divide is huge. It is not so in other traditions that includes in many indigenous cultures. And so there are two kind of ways into that divide. And I think it's people talking about human rights who also have to grapple with this, and educating about human rights who also have to grapple with this. One is through the idea of the right to a clean, healthy, and sustainable environment, which includes as a subcomponent healthy ecosystems and biodiversity as something that humans depend upon. So then it becomes not so much one or the other, but they're both intertwined. The other is, if you think of human rights as including indigenous rights, which indigenous peoples do, then through that, you can get, as I was trying to illustrate, to the idea of nature as rights holder or reciprocal responsibility. So I think it's a really important conversation. And it's also, it's challenging because people working in the human rights space don't tend to get that very much. And we need to talk about that. I just wanted to say two quick things. One is, I find it really interesting when there's a push for criminal sanction, because one of the other things I was very ignorant of when I started the work that I was doing was how badly Canada does at enforcing environmental laws, the lack of criminal enforcement, the challenges, regulatory systems. We have a huge access to justice problem. We're not even part of procedural environmental rights treaties that other countries are. If you bring cases, you're going to get stuck with the costs of the losing party, of the other party if you lose, right? There are huge disincentives for people to actually bring environmental cases here. And that's a big problem. And then just the last sort of thing is, we talked about forum nonconvenience. I see federalism challenges in the Canadian context as equivalent to forum nonconvenience. People are bringing federalism challenges so as to avoid actually talking about the substantive issues that need to be addressed. I'll stop there.
Anyone else?
Okay, yeah, sure. Okay. Right. Okay, yes. Okay, so the first question. And that's a very important point because I guess I mean some years ago China started while people weren't looking, just sort of starting to lock down supplies of all the, critical green economy minerals. And then all of a sudden, one day, people realized, oh, China's got a stranglehold on the world supplies of lithium, nickel, cobalt, etc. And into that that whole discussion, Canadian mining companies have come in and said, we're going to help Canada become a leader in the critical minerals in the green technology. And lost in all of this is the need for a just transition to a green economy and fair extractive practices. And that's definitely a very important point. And then that needs more, highlighting in the public discourse and advocacy. For sure. The second question, I'll just tell a story, is that when our friends in Ottawa were campaigning for the core so many years ago, I tell the story. Well, it's we were coordinating and they were consulting with us. What are the kinds of what are the things that would help you? What are the things that we don't want to impede your work, right? And one of the things that us being the civil litigation people, and one of the things that they did was that they asked the government to put something on the core website that said none of this is meant to preclude any civil remedies in Canadian courts against Canadian companies, right? And so predictably, when we got to Supreme Court and Nevson came up and said, oh, the fact that they established the core and did not enact civil liability for Canadian companies for violations of customary international law is a affirmative signal of their intent for there not to be civil remedies for violations of customary international law. And then we just got up and pointed to that website that said, specifically, this is not meant to preclude that. And that ended up in the judgment. And that sentence later disappeared from the website. So I'll just tell that story. And then I don't know if I can answer the third question. I wouldn't mind speaking a little bit to some of Jed's questions from the earlier panels about securities litigation. Just your third question about accredited investors and how they can either have $1 million in assets or $200,000 in income, or now in the US answer a quiz and participate in private markets. And you're saying, well, how come casinos, anyone can walk to a casino and bet as much as they want? And I see what you're saying. I just am not sure that's quite the right analogy, because these casinos in Canada, at least, they have licenses to operate, right? So they're regulated. I think the better analogy to casinos is public markets, and of course anyone can go sign up for Robinhood and buy as many call options as someone will sell them on public markets, right? But I think the more apt analogy is like if I started running a casino out of my house or something, that's just illegal, no matter how many quizzes you answer or anything, right? Or how many millions of dollars you have in assets, right? So gambling is actually a highly regulated space in Canada. It's not just anyone can go and gamble wherever they want. I'm not saying it sounds like it may be a good idea to allow people who just demonstrate a certain amount of financial literacy to enter and participate in private markets. But I'm not sure. But I just want to say, gambling is also a very highly regulated space as well. Yeah.
Do we have another minute for anybody else?
I would just jump in on those questions and just sort of say, I think that the core is viewed as an alternative to civil litigation. And, it was in the NEFSUM agreements, so that's decisions, so that's good. And what we hope is that that's the part of the carrot and stick, that we're there. and that they can use us and will be viewed as come to us first before you get taken to court, which Nevsan has potentially opened the door for that. And I would also say, like, working together, the core, I mean, we're providing advice to companies and to the government on human rights and environmental due diligence. We're providing it, we'll expect to receive and be making decisions on FPIC and sort of indigenous rights. We'll be looking to many of the, like Sarah and others that are out there writing as to how that's interpreted, how it's applied. We'll be looking to the UN guiding principles, the OECD guidelines. All of the work that anybody out there does on those things will be incorporated into how we hold companies accountable and our decisions and our recommendations. So we do rely a lot on all of the work that's going on out there, including the criticisms of our office and how it can be improved, and adding our voice to that, and our experience.
Okay, I think that's good. Time to cut it off. Join me in thanking all of our panelists. I'll turn it over to Barnali for some closing remarks.
So thank you, everybody, for being here today. Thank you for our last panel. Thank you to all the panelists and all the speakers that have been here. Thank you to all of our guests that have come and joined us for this conversation, both in person and online. I hope that we have come to, or that we've had some very engaging, interesting discussions. I hope we have made some of the interconnections that I was aspiring for at the beginning of this day and when I planned this conference. And I encourage you to continue discussing these issues both with each other and with others. So thank you very much.